Next. Page 5.2 The President. 5.2.1 Election, term of office, and removal. Election process. The National Assembly, NA, elects the President from its members after a general election or when a vacancy occurs. The President serves as both head of state and head of the national executive. The election must be held as per a date determined by the Chief Justice. If filling a vacancy, the election must occur within 30 days of the vacancy. Upon election, the President must swear an oath of office, affirming loyalty to the Republican Constitution, per Schedule 2 of the Constitution. Role of the President. The President is both head of state and head of the executive, holding a central role in governance. Responsibilities include upholding the Constitution, fostering national unity, and maintaining order, peace, and stability. The President has the final say on national legislation and appoints key role players in governance. Term limits. The President may serve 2 full terms, usually 10 years. If filling a vacancy, the period before the next election does not count towards the term limit. Example: Cyril Ramaphosa was elected in 2018 to fill a vacancy, but his first full term began in 2019. Indirect election. While the President is not directly elected by the voters, they are indirectly elected through the NA, which often selects the leader of the majority party as president. Voters indirectly confirm the choice by voting for the party in general elections. Removal of the President. The NA can remove the President via 2 methods. 1. Section 89(1). The NA may adopt a resolution for removal with a 2/3 majority if grounds such as serious violation of the Constitution or law, serious misconduct, or inability to perform presidential duties, are found. 2. Impeachment process, often referred to as impeachment, though not in the Constitution. Removal is not possible without one of the specified grounds being established. The Constitutional Court held in EFF2 that the NA's failure to adopt procedures for Section 89(1) removal was unconstitutional, leading to the requirement of rules tailored to such a process. Case law. Economic Freedom Fighters v. Speaker of the National Assembly, Democratic Alliance v. Speaker of the National Assembly, EFFI. This case highlights the President's role and responsibilities in upholding national unity, law, and constitutional obligations. EFF2, the Constitutional Court ruled that the NA must establish specific rules for the impeachment process under Section 89(1), invalidating the use of ad hoc committees for such a significant action. Next. Page. The impeachment process in South Africa is a hybrid of both fact-based and political elements. Fact-based process. Section 89(1) of the Constitution establishes specific grounds for impeachment, such as serious violation of the Constitution or the law, serious misconduct, or inability to perform presidential duties. The first step of the impeachment process involves determining whether any of these conditions are met. This is a factual inquiry, based on evidence and legal principles. Political process. The second step is a political process, where the National Assembly, NA, after establishing the facts, votes on whether to remove the President. This requires a 2/3 majority. The decision of whether or not to proceed with impeachment may be influenced by political factors, such as party loyalty, political strategy, or the interests of the majority party. Even if the President has violated the Constitution or the law, political dynamics may prevent impeachment if enough members of the NA vote to support the President. Constitutional duty. MPs have a constitutional duty to uphold constitutional values and serve the people, as outlined in the United Democratic Movement v. Speaker of the National Assembly and others, UDM, case. This means MPs must prioritize constitutional duties over party allegiance, especially when holding the President accountable. Failure to uphold this duty could be considered a failure to serve the public and protect the Constitution, especially if MPs do not support impeachment despite clear violations of the law or Constitution. Political influences. While fact-based criteria drive the initial determination of whether impeachment is warranted, the political nature of the NA means that MPs are often swayed by party loyalty, particularly in a closed-list proportional representation electoral system. MPs may avoid voting for impeachment if it goes against the interests of their political party or leadership, resulting in potential political retribution. This creates the possibility that a president may survive impeachment even after being guilty of serious misconduct, simply due to the political calculations of the ruling party. Role of the Speaker. The Speaker of the National Assembly has the discretion to decide whether the vote on a motion of no confidence should be open or secret. This decision is crucial in ensuring effective executive accountability, as a secret ballot may protect MPs from party pressure and allow them to vote in accordance with their conscience, while an open ballot might expose MPs to political consequences. Case law. UDM case. The Constitutional Court emphasized that MPs must prioritize constitutional values over party loyalty, affirming their duty to serve the people and protect the Constitution. Mazibuko v. Sisulu. This case allowed any MP to propose a motion of no confidence, enhancing the ability to hold the president accountable outside of party control. Speaker's discretion. The Constitutional Court confirmed that the Speaker has the discretion to decide on the type of ballot for a motion of no confidence, ensuring the vote is free from party political influence or dishonesty. In summary, the impeachment process begins with an impartial, fact-based assessment of the president's actions but is influenced by political considerations when it comes to the final decision by the National Assembly. Next page. The removal of Thabo Mbeki, political versus constitutional process. Event overview. The ANC's National Executive Committee, NEC, decided to recall President Thabo Mbeki in 2008, a decision that created legal and constitutional uncertainty. Reverend Frank Chikane, in his book 8 Days in September, The Removal of Thabo Mbeki, describes how Mbeki's legal advisors were uncertain about the constitutionality of this action, raising questions about whether the NEC, a political party, had the constitutional power to remove the president. Constitutional framework. The Constitution stipulates that only the National Assembly, NA, has the power to remove the president through a motion of no confidence under Section 102. The NEC of the ANC does not have such power. This means Mbeki had no legal obligation to resign based on the NEC's recall decision alone. Political consequences. Despite no constitutional duty to obey the recall, Mbeki faced potential political consequences for defying the ANC. Disciplinary action could have been taken, potentially leading to expulsion from the ANC. ANC members in the NA would have likely been instructed to pass a motion of no confidence in Mbeki, forcing his resignation. In practice, the political pressure from the ANC and party discipline made Mbeki's resignation almost inevitable. Weakness in constitutional provisions. The absence of explicit provisions in the Constitution governing the relationship between political parties and elected officials is seen as a potential weakness in South Africa's constitutional framework. The situation highlighted the complex interplay between party loyalty and constitutional duties for elected officials. Vacancy in the office of the President. Conditions for vacancy. A vacancy arises in the office of the President when the President is absent from the Republic. The President is unable to perform duties, for example, illness. The President resigns, dies, or is removed from office, for example, through a motion of no confidence. Appointment of acting President. The Deputy President typically assumes the role of acting President in case of a vacancy. If the Deputy President is unavailable, the following officials are designated to act as President, in order. 1. A minister designated by the President. 2. A minister designated by the Cabinet, if no prior designation is made. 3. The Speaker of the National Assembly until a member is appointed by the NA. Oath of office. Before assuming the responsibilities of the President, the acting President must swear or affirm faithfulness to the Republic and obedience to the Constitution, as per Schedule 2 of the Constitution. This oath does not need to be repeated for subsequent terms as acting President until a new President is elected. Powers of acting President. The acting President has all the powers and responsibilities of the President, ensuring that the executive continues to function smoothly without any power vacuum. This framework ensures that, in the event of the President's resignation or incapacity, there is always a clear line of succession, preventing disruptions to governance. Next page. The President is head of state and head of the executive. Powers and distinction. The President holds powers as both the head of state and the head of the national executive. These powers are conferred by the Constitution. Head of state powers are exercised alone by the President, without the need for consultation with the Cabinet. Head of the executive powers are exercised in consultation with the Cabinet. Limitations on head of state powers. The President cannot abdicate their head of state powers by unlawfully delegating the power, acting under dictation, following instructions without independent decision-making, passing the buck by referring decisions to others. While consultation with ministers and advisors is allowed, the final decision rests with the President. Constitutional Court oversight. The Constitutional Court can review the exercise of head of state powers, ensuring that they align with the Constitution and do not violate the Bill of Rights or principles of legality. Distinguishing head of state and executive powers. The distinction between head of state and head of the executive is sometimes unclear. However, the Constitution provides clarity by categorizing powers in separate sections. Head of state, non-political powers that represent all citizens, for example, signing bills, appointing ambassadors, granting pardons. Head of the executive, political powers tied to government functions, for example, appointing ministers, implementing legislation, forming policies. _ Historical context of the president's dual role. Historical precedent. Historically, South Africa followed a system where the Governor-General, before 1961, or state president, after 1961, held head of state powers, while the Prime Minister held executive powers. This system mirrored the UK's roles of the monarch, head of state, and Prime Minister, head of the executive. After 1983, both roles were combined into one executive state president, and this continued under the 1994 interim and 1996 constitutions, with codified powers in sections 82(1) and 84(2) of the interim and final constitutions, respectively. _ Head of state powers. Section 84(2) of the Constitution, powers exercised solely by the President include assenting to and signing bills, referring bills to the Constitutional Court for review, summoning Parliament for extraordinary sittings, appointments, for example, ambassadors, commissions of inquiry, granting pardons, reprieves, and remitting fines. Case law. Public Protector v. President of RSA. The High Court ruled that the Public Protector's remedial powers include instructing the President to act in the President's capacity as head of state, for example, appointing a commission of inquiry. In this case, the President's conflict of interest led to a decision that the Chief Justice should select the chair of the commission. Corruption Watch case. The High Court stated that if the President is conflicted, the Deputy President must perform the President's duties, preventing the conflicted President from making decisions. _ Head of Executive Powers, Sections 85(1) and 85(2), Executive Authority. The President is vested with executive authority by Section 85(1) and shares the exercise of this authority with the Cabinet, Section 85(2). The President's role includes appointing the Deputy President, Cabinet Ministers, and others, such as heads of state-owned enterprises and law enforcement agencies. Executive functions. Implementing national legislation, except where otherwise provided by the Constitution or Parliament. Developing and implementing national policy. Coordinating the functions of state departments and administrations. Preparing and initiating legislation. Appointing key officials like the National Director of Public Prosecutions, National Commissioner of Police, and others in state institutions. _ In summary, the President in South Africa holds a dual role with distinct responsibilities. As head of state, the President exercises powers representing all citizens, with no obligation to consult the Cabinet but with checks on the exercise of these powers. As head of the executive, the President works with the Cabinet to manage the government and implement policy and legislation, holding significant decision-making authority over appointments and state operations. Next page. Formal power of the President to appoint and dismiss, constraints by internal party political considerations. Constitutional authority. The President has the constitutional authority to appoint and dismiss the Deputy President, Cabinet Ministers, and Deputy Ministers. However, in practice, this power is often constrained by political considerations, particularly the relationship between political parties in the executive. Party political influence. Presidents often informally consult the leadership of the governing party before making appointments or dismissals to ensure political support and retain the confidence of their party. This party political influence constrains the exercise of the formal power vested in the President. Example, in 2015, President Zuma fired Finance Minister Nhlanhla Nene and replaced him with Dave Van Rooyen, which led to significant public outcry and market instability. The decision was reversed after resistance from within the ruling party. Administrative capacity of the presidency. The administrative capacity of the presidency has expanded significantly since 1994. Under Nelson Mandela, efforts were made to transform the public service and enhance the role of the presidency, including the Presidential Review Commission on the Reform of Public Service. These reforms centralized power within the presidency, a trend that continued under Thabo Mbeki and Jacob Zuma, with the creation of new ministries such as the National Planning Commission and the Minister of Performance and Evaluation. Underscore. Does the Constitution concentrate too much power in the hands of the President? Concerns over excessive power. Deputy Chief Justice Mosenenke highlighted concerns about the concentration of power in the hands of the President, particularly regarding the President's powers of appointment, which extend across various branches of government and public institutions. The President has the authority to appoint key figures such as Deputy President, Cabinet Ministers, and Deputy Ministers, Ambassadors, the Chief Justice, and other judicial figures. Heads of important public institutions, for example, National Director of Public Prosecutions, Public Protector, Auditor General, Commissioners of various public commissions, the military, and the intelligence services. The problem of political accountability. The concentration of powers in the hands of the President may raise concerns about accountability, especially given that the President has historically been the leader of the dominant party in Parliament. The political system in South Africa, with its strong party discipline and the electoral dominance of the ruling party, has led to an increase in the executive's power. Checks and balances. The limited role of Parliament, due to its relatively weak structure and the influence of party politics, raises questions about whether it should have a greater role in distributing these powers. The courts may be called upon to intervene and ensure that the President and the executive do not exceed their constitutionally granted powers. Underscore. These sections discuss the significant powers vested in the South African President, both constitutionally and in practice, and the impact of party politics on the exercise of these powers. It also touches on concerns about the concentration of power and the need for checks and balances. Next page. Limits on the exercise of presidential power. Constitutional constraints. The President must exercise their powers in line with the Constitution, particularly the founding values and the Bill of Rights. Formal limits exist through specific constitutional provisions, such as the President must appoint judges based on recommendations from the Judicial Service Commission, JSC, and cannot exercise independent discretion. Appointments of the Public Protector, Auditor General, and Commissioners of several constitutional bodies are made on the recommendation of the National Assembly, NA. The President can only appoint individuals with the required qualifications, for example, Head of the National Prosecuting Authority. Case law, Corruption Watch 2. The Constitutional Court ruled that the President's appointment of the National Director of Public Prosecutions, NDPP, was invalid because the prior removal of the previous NDPP was unconstitutional. The President cannot unilaterally extend the term of the NDPP or suspend them without pay, as this would undermine the independence of the National Prosecuting Authority. Consultation requirements. The President must consult with the JSC and opposition leaders in the National Assembly before appointing the Chief Justice, Deputy Chief Justice, or President and Deputy President of the Supreme Court of Appeal. Failure to consult appropriately can render appointments unlawful. Decisions made by the President must be written and may require countersignature by another cabinet member when related to that member's duties. For example, appointment of ambassadors requires countersignature by the Minister of International Relations. Substantive limits. The President's power is also constrained substantively by the Constitution. The exercise of power must not infringe upon the Bill of Rights. The President must act lawfully and rationally, with decisions subject to judicial review. Courts can review decisions taken by the President on the grounds of the rule of law and the doctrine of legality. The President must act in good faith and not exceed their constitutional powers. Judicial review and separation of powers. Courts must balance their duty to enforce constitutional provisions with the respect for the President's political discretion. The courts are hesitant to intervene in decisions involving political discretion unless those decisions violate constitutional principles. Constraints in practice. The Bill of Rights places a substantive constraint on the President's exercise of power, ensuring actions do not violate protected rights. In President of the Republic of South Africa v. Hugo, the Constitutional Court emphasized that the President's exercise of power, for example, granting pardons, must not infringe on rights, particularly equality. However, the court acknowledged that some purely political actions may not lead to constitutional review if they do not affect constitutional rights directly. Application to broader executive. The principles that limit the President's power also apply to other executive members, including provincial premiers and MECs, highlighting the broader scope of these constraints across the executive branch. Underscore. These points summarize the formal and substantive limits on the President's power, emphasizing the constraints established by the Constitution and case law, along with judicial review mechanisms. Next page. Exercise of presidential power, appointments, dismissals, and head of state powers. Appointments and dismissals. The President has significant discretion in appointing or dismissing the Deputy President and Cabinet members. While the President must adhere to the Bill of Rights, it is difficult to challenge decisions based on equality rights when it concerns the appointment or dismissal of Cabinet members, such as in cases involving gender, HIV status, or sexual orientation. Miset Levy, President of the Republic of South Africa, the Constitutional Court ruled that the dismissal of the head of the National Intelligence Agency, NIA, did not require procedural fairness, as it was considered an exercise of executive power, not administrative action. The court emphasized the need for the executive to act efficiently and promptly. Constitutional constraints. The President's decisions are reviewable, even if not on the basis of the Bill of Rights, due to the Constitution's supremacy and respect for the rule of law. Reviewability depends on the nature of the power exercised. If the power affects only one individual or is related to political duties, it may be difficult to challenge based on the Bill of Rights. However, if the President exercises power affecting many, it may open the door for challenges. Limits on head of state powers. President of the Republic of South Africa v. Sarfu 3, the President's decision to appoint a commission of inquiry was challenged. The court ruled that the President did not need to provide a hearing before appointing the commission, as the powers conferred under Section 84(2) of the Constitution are discretionary and not subject to the same administrative requirements. The court clarified that powers such as the appointment of commissions of inquiry and the conferral of honors are policy-driven and not administrative in nature. The President's exercise of these head of state powers is constrained by the Constitution, requiring that decisions be made personally and recorded in writing, not infringe on the Bill of Rights, be guided by the principle of legality, good faith, and proper exercise of powers. Nature of head of state powers. Powers such as appointing commissions, conferring honors, and pardoning offenders are policy-related and not directly tied to the implementation of legislation. These powers, while discretionary, must still comply with constitutional constraints, including non-infringement of rights and legality, even though they are not considered administrative actions. These points outline the scope and limitations of presidential powers in appointments, dismissals, and other executive functions, emphasizing the balance between discretion, constitutional constraints, and the principle of legality. Next page. Limits on the exercise of presidential power. Sarfu 3 Judgment. The judgment illustrates that while the Constitution places limits on head of state powers, these limits do not always require the President to consult those affected by decisions or to adhere to administrative action requirements. The court later added a qualification, acknowledging that the President has unqualified discretion in certain head of state powers, but this discretion is not absolute. Requirement for constitutional or legislative authorization. The President's powers must be derived from the Constitution or a constitutionally valid law. This ensures that the President cannot lawfully act unless explicitly or implicitly authorized by the Constitution or valid legislation. Power to act must be clearly conferred or implied by the Constitution. Misetla case. Legal question: whether the President had constitutional authority to dismiss the head of the National Intelligence Agency, NIA. Section 209 of the Constitution grants the President the power to appoint the head of each intelligence service but is silent on dismissal powers. The court held that the power to dismiss is necessary to give effect to the power to appoint, as the President could not effectively manage the NIA without the ability to remove its head. This power to dismiss is implicitly part of the power to appoint. The court ruled that the dismissal power must be read into Section 209(2) of the Constitution. Limits on parliamentary delegation. Parliament cannot delegate its plenary legislative power to the President unless authorized by the Constitution. Any delegation of legislative authority must be constitutionally valid and authorized by the Constitution. Whether Parliament can delegate powers depends on constitutional interpretation, considering the language and context of the constitutional provision. These points highlight the balance between the President's discretionary powers and the need for constitutional authorization, as well as the limits on legislative delegation to ensure actions remain within the scope of constitutional law. Next page. Delegation of legislative powers and separation of powers. Executive Council of the Western Cape Legislature v. President of the Republic of South Africa. Charles Carlson P's statement. The 1993 and 1996 constitutions mark a clear departure from the past by establishing the Constitution as supreme. The Constitution grants lawmaking powers to the legislature, not the executive. The power of the legislature to delegate the authority to amend or repeal laws is generally not permitted because it would violate the Constitution's manner and form requirements for lawmaking. Parliament cannot delegate the power to amend legislation to the President unless absolutely necessary, for example, in a time of war or an exceptional situation. Allowing Parliament to delegate such powers to the executive could undermine Parliament's role, breach the separation of powers, and result in executive control over legislation. Justice Alliance of South Africa v. President of the Republic of South Africa, and related cases. The President attempted to extend the term of office of the Chief Justice based on Section 8A of the Judges' Remuneration and Conditions of Employment Act. Section 8A of the Act gave the President the power to extend the Chief Justice's term until they reached 75 years of age. Section 176(1) of the Constitution specifies that a constitutional court judge serves for a non-renewable term of 12 years or until the age of 70, unless Parliament explicitly extends the term. Constitutional Court's ruling. The court found that the power to extend the term is constitutionally conferred on Parliament, not the President. Textual indicators. Section 176(1) clearly shows that Parliament, not the President, has the authority to extend a constitutional court judge's term. Delegation of legislative power. In a constitutional democracy, Parliament may not delegate its essential legislative functions, such as extending a judge's term, as this relates to judicial independence and the separation of powers. The power to extend the term of a constitutional court judge is considered an essential legislative function and could not be delegated to the executive. These cases underscore the importance of maintaining the separation of powers and safeguarding the essential functions of each branch of government, particularly in cases where the delegation of powers could undermine the Constitution's principles. Next page. Key constitutional considerations on judicial independence and rationality in executive power. 1. Judicial independence and the Chief Justice's term. The Constitutional Court emphasized the importance of protecting the independence of the judiciary, particularly the Chief Justice, in a constitutional democracy. Section 176(1) of the Constitution provides that the term of a constitutional court judge is non-renewable, 12 years, or until the age of 70, with the exception of an Act of Parliament extending the term. The Court's ruling. The power to extend the term of the Chief Justice lies exclusively with Parliament, and any attempt to delegate that power, such as through Section 8A of the Judges' Remuneration and Conditions of Employment Act, is unconstitutional. The constitutional imperative of judicial independence requires that such decisions be made by Parliament to avoid any perceived external interference by the executive. Delegation issue. Section 8A provided open-ended discretion, which violated the principle of judicial independence. It created a reasonable perception that the judiciary might be subject to external interference from the executive, undermining its independence. Conclusion. The Court stressed the critical role of Parliament in preserving judicial independence by ensuring the term of office of constitutional court judges is not subject to executive control. 2. Rationality in the exercise of presidential power. The rationality requirement for presidential actions is an essential part of the principle of legality and rule of law, ensuring that the President exercises power within constitutional constraints. Rationality standard. The President must act rationally when exercising constitutionally authorized powers. Rationality does not equate to reasonableness. While the reasonableness test evaluates if a decision could have been reached by a reasonable decision-maker, rationality only examines whether the means selected by the President are related to achieving the objective. Key cases. L. Butte v. Center for the Study of Violence and Reconciliation. The Court explained that courts would not interfere with the means chosen by the executive unless they are not rationally related to the objective. Democratic Alliance v. President of South Africa. The Court clarified that the rationality test evaluates the relationship between the means and the end goal, not whether better alternatives exist. As long as the means chosen by the President are rationally linked to the objective, the decision is constitutional. Application. The rationality test is typically easy for the President to meet, and courts cannot substitute their judgment on the appropriateness of the means chosen by the President. They can only intervene if the decision is objectively irrational. These principles reinforce the constitutional balance between protecting judicial independence and ensuring executive decisions are rationally justified. thereby maintaining the integrity of the separation of powers in South Africa's democracy. Next page. Rationality in the exercise of presidential power. 1. Rational relationship between purpose and means. The President must ensure that the means used to achieve a constitutionally permissible objective are rationally related to the purpose sought. The discretion of the President, and the Executive, in selecting means is broad, but it must still be connected to the constitutionally valid objective. Courts' role. Courts cannot interfere with the means chosen by the President simply because they disagree or because alternative means could have been better. 2. Abuse of power and judicial review. If the President abuses power or misconstrues powers, a court can review and set aside the decision. Example, if the President grants a pardon in exchange for a bribe, the court would invalidate such a decision. Principle: all public power, including presidential power, must comply with the Constitution, supreme law, and the doctrine of legality, part of the rule of law. The exercise of presidential power must be rationally related to the purpose for which it is granted. 3. Albute case. The rationality requirement applies not only to the decision itself but also to the process by which the decision is made. In Albute, the Constitutional Court found that if the purpose of the President's power, for example, a pardon for reconciliation, is legitimate, the process must also align with that purpose. For instance, if the amnesty process did not allow victims or their families to be heard, it would be deemed irrational, as it contradicts the principle of reconciliation. 4. Democratic Alliance case. The appointment of the NDPP serves the purpose of selecting a conscientious and honest individual. The court found that if adverse findings had been made regarding the honesty of the appointee, the President should have conducted a further investigation. The court determined that ignoring adverse findings and proceeding with the appointment violated the rationality principle, as the decision was not made through a rational process. In essence, the exercise of power by the President, or other executive members, must follow both a rational process and reach a rational conclusion aligned with the purpose of the power. Courts have the authority to review the exercise of power to ensure both the means and process are rationally related to the objective, thus safeguarding against arbitrary or irrational decisions. Next page. Variable standards for rationality review and its implications. 1. Uncertainty and lack of guidance. Du Plessis and Scott criticize the variable standards applied by the Constitutional Court in rationality reviews. They argue that the level of scrutiny varies depending on the case, with some cases receiving stringent scrutiny and others a more deferential approach. This variability leads to uncertainty. Litigants face difficulties deciding whether to challenge decisions. Lawyers struggle to give clear advice to clients due to the uncertainty around the prospects of success. This situation undermines respect for the rule of law, which demands clarity and predictability in the application of legal principles. 2. Problems with variable rationality review. Legal uncertainty. The lack of clear guidelines from the Constitutional Court on how to apply the rationality standard creates confusion for lower courts, lawyers, government officials, and citizens. Without predictability, the application of the law may not meet the requirements of the Hugo case, violating the rule of law. Practical consequences. Uncertainty complicates the ability of litigants to challenge executive conduct, especially when the conduct is shrouded in information that only the government has access to. When the state fails to provide sufficient reasons for its conduct, the government should bear the onus of proving the rationality of its decisions, or else the court should draw adverse conclusions. 3. Burden of proof and rationality challenges. If the state refuses to provide adequate reasons for its actions, courts should require the government to prove that its conduct is rational. While this might be seen as placing a burden on the state, it is mitigated by the low standard that the government must meet to satisfy the rationality test. 4. Caveats in reviewing presidential power. Minister of Home Affairs via Liebenberg, the Constitutional Court emphasized that challenges to the president's conduct must be precise. Courts need to be clear about which specific conduct of the president is unconstitutional. This helps define the scope of the court's jurisdiction and ensures that the president knows which conduct is under scrutiny. Van Abo v. President of South Africa, a concise order is necessary for the same reasons. Clarity about the conduct in question enables the president to decide whether to correct or appeal the ruling. 5. Presidential immunity for moral evidence. Sarfu 3. The Constitutional Court ruled that the President is not ordinarily required to give oral evidence in person. This protects the status and dignity of the president and prevents impediments to the executive's functioning. Courts must balance the public interest in safeguarding the dignity and efficiency of the presidency, the public interest in ensuring that justice is not obstructed by the president's immunity from moral evidence. Courts should consider restraint when ordering the president to give evidence, ensuring that justice is served without undermining the integrity of the executive branch. Key points. The lack of clear guidelines on rationality review creates uncertainty and diminishes respect for the rule of law. The burden of proof may shift to the government if it fails to justify its actions, and courts should draw adverse conclusions in such cases. Challenges to the president's conduct must be precise in order to define the court's jurisdiction and ensure clarity in legal proceedings. Presidential immunity from moral evidence is limited, balancing the need for executive dignity with the need for judicial oversight. Next page. 5.3 The Deputy President and the rest of the Cabinet. 5.3.1 Appointment and removal. 1. Composition of the Cabinet. The Cabinet consists of President, Deputy President, other Cabinet Ministers. The President appoints the Deputy President and other members of the Cabinet. The Deputy President must be appointed from members of the National Assembly, NA. Cabinet Ministers, except for the President and 2 ministers, all must be members of the NA, reinforcing the principle of parliamentary government, similar to the Westminster system. This arrangement ensures executive accountability to the electorate through the NA, but it weakens the separation between the legislature and the executive. This overlap was challenged during the Constitution certification process, but the Constitutional Court upheld this system, explaining that there is no universal model of the separation of powers. In democratic systems, checks and balances are necessary, and a complete separation is not feasible. 2. The role of the Constitution. Section 92(2) emphasizes that cabinet members are accountable to Parliament both individually and collectively for their functions. Cabinet's accountability ensures legislative checks on the executive. 3. The President's power to appoint and remove cabinet members. The President has the authority to remove the Deputy President and other cabinet members. Section 102(1) of the Constitution allows the NA to pass a vote of no confidence in individual cabinet members, excluding the President, prompting the President to reconstitute the cabinet. The President's removal power is considered political and does not adhere to typical fair labor practices, as noted in the Masetla case. Sachs J. distinguishes between the President's dismissal of political appointees and other types of appointees, emphasizing the political nature of cabinet members' roles. 4. Vote of no confidence. Section 102(1) allows the NA to pass a vote of no confidence in individual cabinet members, leading to their dismissal. Section 102(2), in contrast, allows the NA to pass a vote of no confidence in both the President and the Cabinet, leading to their resignation. In theory, this provision provides the NA with significant control over individual cabinet members. However, political dynamics make it unlikely that the NA would pass a vote of no confidence against the cabinet, as most members are loyal to the President and the majority party. A vote of no confidence might occur only if there is a leadership change in the majority party or if there is a coalition government with differing opinions within the NA. 5. Influence of party leadership. 2007 ANC Polokwane Conference, a shift in party leadership illustrated the real power of party leadership in the government. Even when President Mbeki lost the leadership of the ANC, he initially continued as president, but the ANC-NEC eventually recalled him. This event shows the power of the ruling party's leadership in influencing the executive, even without direct membership in the NA or the cabinet. The NEC could have instructed the NA to pass a vote of no confidence in the cabinet, excluding the president, forcing the president to reconstitute the cabinet. This illustrates how party leadership can influence executive decisions through mechanisms like Section 102(1). Key points. The President can appoint and dismiss the Deputy President and other cabinet members. Accountability of the cabinet to the NA ensures checks on executive power. Section 102(1) allows the NA to remove individual members of the cabinet, although political dynamics often prevent this. Party leadership has substantial influence over the executive, as illustrated by the 2007 ANC conference and the potential for party-led challenges to the cabinet. Next page. 5.3.2 Powers of the Deputy President and the Cabinet. Section 85(2). The President exercises executive authority with the Deputy President and Cabinet members, but no specific powers are conferred by this section. Section 91(2). The President assigns powers/functions to the Deputy President and Ministers. Section 91(5). The Deputy President must assist the President in executing government functions. The Deputy President's role is determined by the President. It can range from a ceremonial position to a de facto Prime Minister depending on their relationship and influence within the governing party. Exceptions to general rules. Acting President. If the President is absent or unable to fulfill duties, or during a vacancy in the presidency, the Deputy President automatically acts as President. This also applies if the President is conflicted and unable to exercise specific powers. Cabinet Ministers' functions. The President assigns different portfolios to ministers and tasks them with administering specific pieces of legislation. Accountability. Individual accountability. Ministers are accountable to both the President and the National Assembly, (NA), for their portfolios. Collective accountability. The Cabinet is collectively accountable to Parliament for the national government's performance and policies, as per Section 92(2). Ministers must act together, and if unable to support a decision, they may resign. Individual accountability in Parliament. Section 92(2). Ministers must provide Parliament with reports on matters under their control. Section 92(3)(b). Ministers must report to Parliament regularly about their duties. Cabinet solidarity. Ministers are accountable both individually and collectively, but they must always act in unison, representing a shared responsibility for cabinet decisions. Ethical conduct. Section 96 establishes ethical standards for cabinet members and deputy ministers. Must act with integrity, avoiding conflicts of interest or improper enrichment. Bound by the Executive Ethics Code and cannot accept gifts or benefits improperly influencing their duties. Must declare personal financial interests. Breaches of the Ethics Code are investigated by the Public Protector, who reports findings to the President or Premier. Legal constraints. The exercise of powers by cabinet members must adhere to the Constitution, the Bill of Rights, and the principle of legality. Powers must be exercised in good faith, without exceeding or misconstruing authority. Next page. The role of the Deputy President. Constitutional framework. The Constitution does not define the powers of the Deputy President but states that the Deputy President must assist the President in the execution of the functions of government. The extent of the Deputy President's involvement in government affairs is determined by the President. Debate on role distinction. There is a discussion about whether the President should have a more ceremonial role while the Deputy President acts as a de facto Prime Minister, taking a more active role in domestic policy. French system model. In France, the President is the head of state and controls foreign policy and defense, while the Prime Minister handles domestic policy. If the President and Prime Minister are from different parties, it leads to cohabitation, which may result in gridlock. In South Africa, this situation is avoided as both the President and Deputy President are from the same political party. The potential benefits of a Deputy President acting as a de facto Prime Minister include better division of labor and more effective government. The potential dangers include the development of two centers of power, leading to conflict and paralysis. Summary of the National Executive. Composition and accountability. The National Executive consists of the President, Deputy President, and Cabinet. The President is elected by the National Assembly, (NA), and the President and Cabinet must maintain the confidence of the NA to continue functioning. The President acts as the head of state and head of the executive, requiring a responsible cabinet member to countersign decisions. No confidence and impeachment. Under Section 102, if the NA passes a vote of no confidence in the President and Cabinet must resign. The President can also be impeached under Section 89 for serious violations, misconduct, or incapacity. While the NA has the power to dismiss the President, this is typically unlikely due to the President's control over the majority party. Constraints on the executive. The exercise of power by the President and Cabinet is constrained by the supremacy of the Constitution and must be authorized by the Constitution and ordinary legislation. Judicial review. The judiciary can check the power of the executive. Principle of legality. Powers must be exercised in good faith, rationally, and in accordance with the Constitution and the Bill of Rights. Presidential powers. The President has the power to appoint and dismiss cabinet members and assign their tasks. The President's power is influenced by political considerations, especially when a dominant political party with collective leadership is involved. Cabinet accountability. Individual and collective accountability. Cabinet members are accountable to both the President, who appoints and dismisses them, and the NA. While cabinet members may have differing opinions, once a decision is made, they must collectively support it. In exceptional cases, the NA can adopt a motion of no confidence in individual cabinet members, which could force the president to reconstitute the cabinet. Next. Page 6. Separation of powers and judicial authority. Underscore. 6.1 The historic legacy of parliamentary sovereignty and apartheid on the judiciary. Parliamentary sovereignty. In the pre-1994 era, South Africa operated under a system of parliamentary sovereignty, where parliament was supreme and could make or change laws without judicial interference. Impact of apartheid. The apartheid system influenced the judiciary by placing it in a subordinate position to the executive and legislature, often disregarding human rights and democratic values. Judicial decisions under apartheid were frequently politically influenced, and the judiciary lacked independence, resulting in a legal system that supported apartheid policies. Underscore. 6.2 The appropriate role of courts in a constitutional democracy. Judicial review. Courts play a critical role in maintaining the rule of law, ensuring that laws and actions are in compliance with the Constitution. Role of courts. In a constitutional democracy, the judiciary is tasked with interpreting the Constitution and protecting the rights and freedoms of individuals. Courts act as a check on the power of the executive and legislature, ensuring that they do not exceed their constitutional authority. Underscore. 6.3 The judiciary in the new constitutional dispensation. 6.3.1 The structure of the judiciary in the 1996 Constitution. The judiciary is structured with several levels of courts, ensuring access to justice and effective legal remedies for all citizens. 6.3.2 Constitutional jurisdiction of the various courts. 6.3.2.1 Constitutional Court. The highest court on constitutional matters, with exclusive jurisdiction over constitutional issues. It safeguards the Constitution, ensuring that legislation and actions comply with its principles. 6.3.2.2 Supreme Court of Appeal. The highest appellate court in South Africa, dealing with general appeals. The Supreme Court of Appeal has the final say on most legal matters, except those concerning constitutional issues. 6.3.2.3 High Courts. High courts handle serious criminal and civil cases and can hear constitutional matters if needed. They also have a role in reviewing administrative decisions to ensure they comply with the law. 6.3.2.4 Magistrates' Courts. The lowest level of courts, primarily handling less serious criminal and civil cases. Magistrates' courts serve as the initial point of entry into the legal system. Underscore. 6.4 The independence of the superior courts. 6.4.1 Introduction. Judicial independence is vital for a functioning democracy, ensuring that judges can make decisions free from political influence or intimidation. 6.4.2 Appointment of judges. Judges are appointed through a transparent process outlined by the Constitution, ensuring their independence from political pressure. 6.4.3 The judicial oath of office. Judges take an oath to perform their duties impartially and in accordance with the Constitution, ensuring their commitment to the rule of law. 6.4.4 Security of tenure. Judges have secure tenure, ensuring that they cannot be arbitrarily removed from office. This security protects them from political pressures. 6.4.5 Financial security. Judges are provided with appropriate remuneration to ensure that their independence is not compromised by financial concerns. 6.4.6 Limitation of civil liability. Judges are granted immunity from civil liability for decisions made in their judicial capacity, which further strengthens their independence. 6.4.7 Office of the Chief Justice. The Chief Justice is the head of the judiciary and plays a key role in ensuring its independence and efficient functioning. Underscore. 6.5 Independence of the lower courts and traditional courts. 6.5.1 The lower courts under the interim constitution. The lower courts under the interim constitution were intended to be independent, but their functioning was still influenced by the old regime. 6.5.2 Independence of the lower courts under the 1996 Constitution. The 1996 Constitution ensured that lower courts, like the high courts, are independent from other branches of government, enhancing access to justice. 6.5.3 Independence of traditional courts. Traditional courts, which play a role in certain communities, must operate within the framework of the Constitution, ensuring that their decisions do not violate constitutional rights. Underscore. 6.6 The National Prosecuting Authority. Role. The National Prosecuting Authority, NPA, is an independent institution responsible for prosecuting crimes and ensuring that justice is served. The NPA must operate without political interference, and it plays a crucial role in upholding the rule of law and protecting the public. Summary. The judiciary plays a pivotal role in maintaining the separation of powers and ensuring that the executive and legislature do not exceed their constitutional boundaries. The structure of the judiciary, as defined by the 1996 Constitution, is designed to balance accessibility, fairness, and efficiency. The independence of the judiciary, especially the superior courts, is vital to upholding democratic principles and the rule of law in South Africa. Next page. 6.1 The historic legacy of parliamentary sovereignty and apartheid on the judiciary. Parliamentary sovereignty in pre-1994 South Africa. The South African legal system was grounded in parliamentary supremacy, meaning Parliament's decisions were absolute, and the judiciary had limited power to challenge laws, even those that violated individual rights or freedoms. Under apartheid, this doctrine restricted the judiciary's ability to protect rights and freedoms, as it was bound to enforce laws created by the apartheid legislature. Judicial compliance with apartheid laws. Many judges followed a positivistic approach, interpreting the law strictly according to the legislative intent, regardless of the social injustices those laws caused. While some judges attempted to mitigate the effects of apartheid, many strictly enforced laws that entrenched racial discrimination. Legitimacy of the judiciary. The judiciary was not seen as legitimate by the majority of South Africans due to its complicity in apartheid policies. Courts, especially the highest courts, lacked impartiality. Mtswana notes that the judiciary equated the rule of law with the enforcement of laws enacted by Parliament, regardless of their unjust nature. Anti-apartheid legal victories and judicial reversals. In the 1980s, anti-apartheid lawyers won some significant victories, but the appellate division often overturned these decisions, reinforcing the power of the apartheid state under emergency provisions. The judiciary's reluctance to act decisively against apartheid laws further weakened its credibility. Differing views on judicial legitimacy. Madala argues that apartheid created a society where courts were viewed with suspicion and anger by the majority of the population. Elman claims that, despite apartheid, many black South Africans retained some level of confidence in the legal system, possibly due to the role of anti-apartheid lawyers and the ideals of independent judging. Judicial role under apartheid. Courts were seen as mechanical interpreters of law, lacking the power to question or reverse unjust legislation. Corder describes judges as protectors of stability who adhered to the principle of legislative sovereignty, despite the inherent racial inequalities in the political structure. Formal independence of the judiciary. Before 1994, some formal attributes of judicial independence were in place, such as secure tenure, guaranteed salaries, and open courtrooms. However, judicial appointments were politically influenced, with judges promoted based on political considerations and most judges being white males from privileged backgrounds. Judicial appointment process. Judges were appointed by the state president on the recommendation of the Minister of Justice, often based on political factors. The selection process was opaque, and political connections played a significant role in appointments. Racial composition of the judiciary before 1994. In 1994, the judiciary was overwhelmingly composed of white men, 161 out of 166 judges. There were only 2 white women and 3 black men, with no black women on the bench. The first black male judge, Ishmael Muhammad, was appointed in 1991. The structure of the judiciary. Before 1994, the appellate division, now the Supreme Court of Appeal, was the highest court, hearing appeals from the provincial divisions of the Supreme Court, now high courts. The Supreme Court, along with specialized courts, made up the superior courts, while magistrates' courts handled less serious matters. Traditional courts under apartheid. A separate system of courts was established for African people to interpret and enforce customary law. This system, although originally more democratic, was manipulated under apartheid to serve the government's interests. The traditional court system was controlled by the state, with traditional leaders becoming government functionaries, eroding its legitimacy and democratic values. Next. How can the formation of new judicial structures that would truly deal responsibly with living customary law be achieved? Bani argues that the colonial encounter fundamentally changed the way in which customary law was applied and developed in apartheid South Africa. Apart from the fact that Roman Dutch and English law were preferred over customary law, he argues further The rules of evidence imported from Britain and imposed by statute and convention extinguished many customary law principles and rules. Strict criteria were imposed to prove the legal validity of customs. It had to be proved that customs had existed from time immemorial, and that they were invariable, continuous, certain, notorious, reasonable, peaceable and obligatory. Customs could not be immoral or opposed to an express enactment or to public policy. The rule of stare decisis ended the flexibility of customary law by preventing innovation to meet the changes in community opinion and sentiments. Modern legal machinery forced customary law to fall in line with national standards. 31 Customary law was preserved, upgraded and frozen out of relevance to the flux of the traditional communities' life. 32 This was evidenced by cases such as others v. Kailicha Magistrate and others, Commission for Gender Equality as Amicus Curiae 33 and Shilubana and others v. Nwamitwa, Commission for Gender Equality, National Movement of Rural Women and the Congress of Traditional Leaders of South Africa as Amicus Curiae 34 which focused on the development of customary law through the lens of either the common law or the Constitution. Customary law thus became atrophied as a result of the rupture of its relationship with other sources of law. 35 Even the manner in which customary law was recorded changed. Before the colonial encounter, it was a body of orally transmitted precepts and precedents. 36 Where disputes arose, solutions were sought to take the total situation of the parties into consideration. 37 These basic features were eroded by the Union and apartheid administration, and customary law became a fixed body of law, indistinguishable from statute and case law. Opinions and evidence given by villagers on custom in courts were isolated from their contexts and utilized to describe a single transaction or an offense, which gave rise to a sense of individual right not dependent on community opinion, enforced by courts even in opposition to community opinion. 38 Moseneke J., as he then was, expressed a similar sentiment in Daniels v. Campbell and others. True to their worldview, which originates from the deep-rooted prejudice, judges of the past displayed remarkable ethnocentric bias and arrogance at the expense of those they perceived different. They exalted their own and demeaned and excluded everything else. 39 Given these changes and the transformation during Union and apartheid rule of customary law and the institutions called on to develop and enforce it, it can be argued that the creation of new traditional courts that rely on the discredited structures of traditional leadership runs the risk of entrenching Union and apartheid forms of judicial governance instead of truly respecting age-old customary legal structures. But should the South African judiciary be restructured to enable the formation of new judicial structures that would truly deal responsibly with living customary law? If so, how could this be achieved? There are no easy answers to such questions, as the debate, which started in 2012 with proposals for the creation of new traditional courts, illustrates. 40 Page. Formation of new judicial structures for living customary law. Colonial and apartheid influence on customary law. Vanna's argument. The colonial encounter fundamentally altered how customary law was applied and developed in South Africa. Roman, Dutch and English law were preferred over customary law. Strict criteria were imposed on the recognition of customs. For example, customs must be immemorial, continuous, invariable, reasonable, and aligned with public policy. The rule of stare decisis, precedent, hindered the flexibility of customary law, preventing it from evolving with changing community norms. Consequences: customary law became rigid and disconnected from the evolving needs and practices of communities, losing relevance in contemporary contexts. Impact of legal and judicial transformation. Customary law was preserved, upgraded, and frozen, but this process stunted its ability to adapt to social change. This resulted in a system that was at odds with the living, evolving traditions of communities. In cases like Others v. Kailicha Magistrate and Shilubana and others v. Nwamitwa, the development of customary law was viewed through the lens of common law or the Constitution, rather than considering its roots in living, evolving community practices. Recording and application of customary law. Before colonial influence, customary law was an oral tradition passed down through communities and dealt with disputes holistically, considering the entire context. Under colonial and apartheid rule, customary law became codified and separated from its communal roots. The court system began to treat it like formal statute law, enforcing individual rights rather than communal norms, often against community consensus. This shift to a statutory, case law-based system led to a disconnect between the law and the lived realities of traditional communities. Judicial bias and exclusion. Mosenenke J. and Daniels v. Campbell pointed out that apartheid-era judges had ethnocentric biases that distorted their understanding of traditional practices and disregarded their validity. The judiciary under apartheid exalted Western legal systems while demeaning and excluding indigenous legal structures, reinforcing their disconnection from the community's way of life. Risks of restructuring judicial systems. The creation of new traditional courts risks reinforcing apartheid-era judicial structures, which could perpetuate the same forms of governance that undermine the legitimacy of customary law. A purely traditional approach, relying on outdated and discredited traditional leadership structures, may fail to respect and integrate living customary law, which evolves with community changes. Proposals for judicial restructuring. The debate over restructuring the judiciary to properly address living customary law started in 2012, with proposals for new traditional courts. The goal is to create systems that allow living customary law to be applied responsibly while maintaining the independence and fairness of the judicial system. The challenge is to balance respect for traditional customs with modern constitutional principles. Key considerations for restructuring. Inclusion of community practices. Judicial structures should recognize that customary law is dynamic and rooted in community practices, which evolve with changing social realities. Integration with constitutional framework. New structures should align with South Africa's constitutional principles, ensuring that they respect both individual rights and collective customs. Cultural sensitivity and legitimacy. New judicial structures must be sensitive to cultural traditions and address past biases while ensuring that justice is not compromised by outdated practices. Judicial independence. Courts dealing with customary law should be independent, free from political influence, and able to adapt to modern societal needs. In summary, achieving a system that deals responsibly with living customary law would require careful integration of traditional values with the constitutional and judicial principles of modern South Africa, addressing both past wrongs and the evolving needs of communities. Next. 6.2 The appropriate role of courts in a constitutional democracy. In a constitutional democracy, the judiciary is often referred to as the bastion of the legal order. 41 This is because in a constitutional democracy with a supreme and enforceable constitution, an independent judiciary is free to interpret and apply the law impartially and without consideration of the wishes of politicians, powerful business interests or civil society groups. According to this theory, the system of separation of powers and checks and balances can only operate optimally if an independent and impartial judiciary is empowered to enforce the provisions of the Constitution. In such a system, the judiciary acts as referee of the democratic process while also checking whether the two political branches of government, the legislature and the executive, act within the boundaries set out by the Constitution and by legislation. The more dominant a political party is in government and the larger its majority in parliament, the more likely it is that other role players will revert to the independent and impartial courts to check the exercise of powers of the legislature and executive, and to limit the potential abuse of power and breaches of the Constitution, which some commentators associate with a prolonged period of political dominance by one political party. To the extent that South Africa can still be viewed as a one-party dominant democracy, 42 it can be argued that these tendencies continue to manifest themselves in the South African context. This places the judiciary in a difficult position. On the one hand, it is empowered by the Constitution to enforce its provisions and to declare invalid acts and omissions of the legislature and the executive that fail to comply with the obligations imposed by the Constitution. 43 The judiciary has a duty to enforce the provisions of the Constitution and the law, and to check the exercise of power by the legislature, executive and other powerful role players. From a purely institutional and practical political perspective, the judiciary can appear to be relatively weak in relation to the other two branches of government. It may appear to lack the political clout and democratic legitimacy associated with the elected branches of government and is dependent on the other two branches of government for its funding and for ensuring that its decisions are adhered to. The truth is, as the Constitutional Court has pointed out, that the judiciary cannot function properly without the support and trust of the public. 44 As former Chief Justice Ismail Muhammad explained, unlike Parliament and the executive, however, judicial officers do not have the powers of the purse, the army, and the police to execute their will. All the courts put together in the country do not have a single soldier. They would be impotent to protect the Constitution or to execute the law if the agencies of the state which control the mighty physical and financial resources of the state refuse to command those resources to enforce the orders of the courts. The courts could then be reduced to paper tigers with a ferocious capacity to roar and to snarl but no teeth to bite and no sanctions to execute their judgments, which could then simply be reduced to pieces of sterile scholarship, or futile exhibitions of toothless wisdom. The ultimate power of the courts must therefore rest on the esteem in which the judiciary is held within the psyche and soul of the nation and in the confidence it enjoys within the hearts and minds of potential litigants in search of justice. That esteem and that respect must substantially depend on the independence and integrity of judicial officers. No public figure anywhere, however otherwise popular, could afford to be seen to defy the order of a court which enjoys, within the nation, a perception of independence and integrity. His or her own future would then be in mortal jeopardy. 45 The way in which this tension can best be dealt with is by recognizing that an independent and impartial judiciary is most effective when it respects the separation of powers doctrine and does not unnecessarily intrude on the domain of the legislature and the executive. However, this does not mean the courts must be timid in protecting and enforcing the Constitution. In International Trade Administration Commission v. SCA South Africa, Proprietary, Limited, the Constitutional Court thus said, "In our constitutional democracy, all public power is subject to constitutional control. Each arm of the state must act within the boundaries set. However, in the end, courts must determine whether unauthorized trespassing by one arm of the state into the terrain of another has occurred. In that narrow sense, the courts are the ultimate guardians of the Constitution. They do not only have the right to intervene in order to prevent the violation of the Constitution, they also have the duty to do so. It is in the performance of this role that courts are more likely to confront the question of whether to venture into the domain of other branches of government and the extent of such intervention. It is a necessary component of the doctrine of separation of powers that courts have a constitutional obligation to ensure that the exercise of power by other branches of government occurs within constitutional bounds. But even in these circumstances, courts must observe the limits of their own power. 46 Courts must therefore act in a restrained but principled manner and must interpret and enforce the Constitution in a fearless way. This will help to ensure that the political process remains fair, democratic space remains open and political contestation remains robust, while also playing a decisive role in protecting the vulnerable and marginalized in society. 47 When considering the role and functions of the judiciary, it is important to take note of this broader context within which the judiciary operates. This section of the chapter therefore focuses on the powers, functioning and composition of the judiciary in the light of the pressing need for the judiciary to retain the esteem and respect of the wider society while also scrupulously enforcing the Constitution and the law in an impartial and independent manner. This will be done against the background of the separation of powers doctrine. Page. The role of courts in a constitutional democracy. Judiciary as the bastion of the legal order. In a constitutional democracy, the judiciary is crucial in ensuring the Constitution is upheld and the separation of powers operates effectively. An independent judiciary interprets and applies laws impartially, without political influence, and ensures that the legislature and executive act within constitutional boundaries. The judiciary plays a role as a referee of the democratic process, protecting the Constitution from abuses by the political branches of government, especially in cases of prolonged political dominance. Challenges in South Africa's one-party dominant democracy. South Africa's political landscape, where one party dominates, creates tensions as the judiciary checks the powers of the legislature and executive, who have significant control over the resources and enforcement of court decisions. The judiciary, despite its constitutional duty to enforce laws and check the political branches, may appear weak compared to the other branches in terms of political power and public legitimacy. Judiciary's role in public trust. The effectiveness of the judiciary hinges on its credibility and the public's trust. Judicial officers do not control the physical and financial resources necessary for enforcing decisions, for example, the army, police. Former Chief Justice Ismail Muhammad explained that without the support of the state's resources, courts could become powerless, reducing their judgments to mere theoretical expressions. Courts derive their power from the esteem and integrity they command within society, making public perception of their independence and fairness essential to their functioning. Balancing judicial independence and separation of powers. The judiciary must balance independence with respect for the separation of powers, ensuring it does not overstep into the legislative or executive domain unnecessarily. This does not mean judicial timidity. Courts must act fearlessly to protect the Constitution and ensure government actions comply with constitutional limits. Constitutional Court stance on judicial intervention. In International Trade Administration Commission v. SCA South Africa, The Constitutional Court emphasized that all public power is subject to constitutional control. Courts have the duty to intervene when one branch of government oversteps its bounds into the jurisdiction of another. However, courts must carefully consider the extent of such intervention and avoid overreach. Principled and restrained intervention is necessary to uphold constitutional governance while respecting the roles of the other branches of government. Ensuring fair and democratic political space. The judiciary's role includes ensuring fairness in political processes, maintaining an open democratic space, and protecting the vulnerable and marginalized. Courts must be fearless in enforcing the Constitution while respecting the broader context in which they operate. Contextual overview. The judiciary's composition, powers, and functioning must be considered against the separation of powers doctrine, with the ultimate goal of retaining public esteem while upholding the Constitution and the law impartially and independently. Next page. Judicial overreach, a debate on constitutional court intervention. Key question. Should the Constitutional Court defer to the other branches of government, or is it its duty to intervene, even when such intervention might intrude into the powers allocated to the legislature or executive by the Constitution? Case example, economic freedom fighters and others v. Speaker of the National Assembly in another. The case revolved around Section 89 of the Constitution, which outlines the mechanisms for impeaching the president. The question was whether the National Assembly's procedures for impeachment complied with the Constitution, and whether the courts had the right to intervene and instruct the Assembly to adopt a new procedure. The majority of the Constitutional Court held that the judiciary had a constitutional duty to ensure compliance with the Constitution, even if it meant interfering with the legislature's domain. The court ordered the National Assembly to amend its rules to align with the court's interpretation of impeachment procedures. Chief Justice Mogoeng disagreed, labeling the majority's intervention as judicial overreach, an unconstitutional intrusion into Parliament's exclusive powers. Chief Justice Mogoeng's dissent. Mogoeng characterized the decision as a constitutionally impermissible intrusion into the exclusive powers of Parliament, highlighting the polycentric and controversial nature of the issue. He argued that the separation of powers doctrine prevented the court from prescribing to the National Assembly how it should conduct impeachment proceedings, including the requirement to hold inquiries or always determine grounds for impeachment before debating and voting on a motion. Mogoeng emphasized the importance of judicial restraint, especially when dealing with matters that fall within the legislative domain. Justice Frunman's response. Frunman defended the majority decision, explaining that reasonable disagreements on constitutional interpretation are inherent in judicial adjudication. He argued that it was not appropriate to label the dissenting view as an abdication of responsibility. Rather, both views were legitimate, but the majority's interpretation was aligned with ensuring the National Assembly acted in accordance with the Constitution. Frunman suggested that the robust debate on constitutional interpretation should focus on substantive reasons rather than personal judgments, emphasizing the serious and honest reasoning behind the majority decision. Judicial overreach versus constitutional duty. The debate centers on whether the intervention of the judiciary into matters traditionally reserved for the legislature constitutes overreach or if the courts are simply fulfilling their duty to interpret and uphold the Constitution. Critics of judicial intervention, like Chief Justice Mogoeng, argue that courts should not intrude on the legislative or executive branches unless absolutely necessary, particularly when the issue at hand is controversial or polycentric, involving multiple factors and stakeholders. Proponents of the majority view, like Justice Frunman, contend that the Constitution is supreme, and when the legislature fails to comply with constitutional requirements, the judiciary is obligated to intervene to enforce the Constitution, especially in cases where fundamental constitutional principles are at stake. Personal opinion. The disagreement highlights the delicate balance courts must maintain between respecting the separation of powers and fulfilling their duty to protect constitutional rights. While the concept of judicial overreach is important, courts must ensure that constitutional provisions are adhered to, even when this requires judicial intervention. It is the judiciary's role to ensure that all branches of government remain within constitutional bounds, particularly when democratic principles or individual rights are at risk. In this case, the majority decision does not appear to be an overreach, but rather a necessary step to ensure that the National Assembly performs its duties in a manner that complies with constitutional mandates. However, careful consideration must be given to the context of each case to avoid excessive judicial intrusion into areas where the legislature or executive is constitutionally empowered to act independently. Next page. 6.3 The judiciary in the new constitutional dispensation. 6.3.1 The structure of the judiciary in the 1996 Constitution. Restructuring of the judicial system. The 1996 Constitution brought significant changes, including the restructuring of South Africa's judicial system to reflect the new constitutional order. Section 166 of the Constitution outlines the courts that make up the judiciary. The Constitutional Court, the Supreme Court of Appeal, SCA, the High Court of South Africa, and any similar court established by an Act of Parliament, the Magistrates' Courts. Other courts established by Parliament, including those similar to the High Court or Magistrates' Courts. Constitutional Court. A new constitutional court was created to serve as the final court on constitutional matters. Chief Justice heads the Constitutional Court and the judiciary, responsible for setting norms and standards for judicial functions across all courts. Deputy Chief Justice serves as the Chief Justice's deputy, performing assigned functions and acting as Chief Justice when needed. Both Chief Justice and Deputy Chief Justice represent the judiciary in dealings with other branches of government and may perform ceremonial and administrative duties. Location. The seat of the Constitutional Court is in Johannesburg, though it may sit elsewhere if necessary for justice. Supreme Court of Appeal, SCA. The Appellate Division was renamed the Supreme Court of Appeal, SCA, becoming an independent constitutional entity. Headed by the President of the SCA, assisted by the Deputy President. Location. The SCA's seat is in Bloemfontein, but it can sit elsewhere in the country if required for justice. The jurisdiction of the SCA is limited in that it does not have jurisdiction over constitutional matters which are exclusively handled by the Constitutional Court. High Courts. High courts were created from previous provincial divisions and courts in the former homelands, now unified under the High Court of South Africa. The High Court functions as a superior court, hearing first-instance cases and appeals from lower courts. It has geographically limited jurisdiction based on its divisions. Divisions include Eastern Cape, Free State, Gauteng, KwaZulu-Natal, Limpopo, Mpumalanga, Northern Cape, Northwest, and Western Cape, with each division having a judge-president. Divisions and jurisdictions. High courts are structured geographically, with divisions based on provinces, and each has a specified headquarters. Magistrates' courts. Magistrates' courts were not changed substantially but are now constitutionally recognized. Magistrates no longer fall under the public service, enhancing judicial independence. They are authorized to decide matters determined by legislation but cannot inquire into the constitutionality of laws or presidential conduct. Specialist courts. Superior specialist courts. Labor court, established by the Labor Relations Act, to handle employer-employee disputes. Land claims court, established by the Restitution of Land Rights Act, to resolve land reform-related disputes. Tax court, established by the Income Tax Act, for tax-related cases. Inferior specialist courts. Children's court, deals with matters related to children, such as custody. Maintenance courts, handles maintenance issues under the Maintenance Act. Domestic violence courts, deals with domestic violence cases, established by the Domestic Violence Act. These specialist courts aim to address specific social issues, promoting constitutional values. However, they typically do not adjudicate constitutional matters except for equality courts. Significance. The restructuring of the judiciary serves to reinforce the independence of the judiciary while ensuring that courts at all levels are empowered to uphold constitutional values and principles. The creation of specialized courts emphasizes the role of the judiciary in addressing the unique challenges faced by society, particularly in areas such as land reform, labor, children's rights, and domestic violence. Next. Page 6.3.2 Constitutional jurisdiction of the various courts. Jurisdiction overview. Jurisdiction refers to the authority of a court to hear, adjudicate, and dispose of legal disputes. In civil matters, litigants must approach the correct court with jurisdiction over the matter. In criminal matters, the National Prosecuting Authority, NPA, must ensure the accused is tried in the correct court, which holds the authority to determine guilt and impose a sentence. A court will dismiss a case if it lacks jurisdiction, even if it has the authority to hear similar cases on appeal. Jurisdiction in constitutional matters. Constitutional cases differ from non-constitutional matters in terms of jurisdiction, as they often involve distinct remedies. Constitutional cases typically involve issues of whether a law or action is unconstitutional and should be invalidated. If a court declares a law or executive action unconstitutional, it interferes with the work of democratically elected bodies, legislature or executive. Constitutional jurisdiction refers to the authority granted by the Constitution to specific courts to adjudicate constitutional matters and issue remedies, such as declaring laws or acts unconstitutional. There is a close connection between the remedy sought in a constitutional matter and the jurisdiction of the court hearing the case. Jurisdictional rules and remedies. The jurisdiction of constitutional courts is tied to the remedy being sought, for example, invalidation of legislation, acts, or executive decisions. There are special rules for when these remedies can be granted and whether the court's ruling is final. Courts with constitutional jurisdiction can issue remedies not typically available in non-constitutional cases. Historical development of constitutional jurisdiction. In the interim constitution, the Constitutional Court was placed on equal footing with the Supreme Court of Appeal, SCA, with the SCA having final jurisdiction over non-constitutional matters and the Constitutional Court overseeing constitutional matters. The 1996 Constitution altered this structure, giving the SCA constitutional jurisdiction, but the Constitutional Court retained final authority over all constitutional matters. Constitutional Court's extended jurisdiction, 2013 Amendment. The Constitution's 17th Amendment Act 72 of 2013 expanded the Constitutional Court's jurisdiction, which now extends to more areas of law. The division of jurisdiction between constitutional and non-constitutional matters is further complicated by this expansion. Challenges in determining constitutional issues. The determination of whether a matter raises a constitutional issue is not always straightforward, which complicates the jurisdictional division between courts. Understanding the distinction between constitutional and non-constitutional matters is key to determining which court has jurisdiction over a case. Next. Page 6.3.2.1 Constitutional Court. Jurisdiction before the 2013 Amendment. The Constitutional Court was a specialist court with jurisdiction over constitutional matters and related issues. It was the final court of appeal for constitutional matters but did not have jurisdiction over non-constitutional matters. Constitutional matters included any issues involving the interpretation, protection, or enforcement of the Constitution. Key case, Pharmaceutical Manufacturers Association of South Africa and another, Henry X. Party President of the Republic of South Africa and others. The Constitutional Court emphasized the unity of law under the Constitution, stating that common law and all law derive their force from the Constitution and are subject to constitutional control. Section 39(2) of the Constitution. Courts must interpret legislation and develop the common law or customary law in line with the spirit, purport, and objects of the Bill of Rights. This means that interpretations of law could raise constitutional issues indirectly, especially where the law deviates from the Constitution's spirit. Jurisdiction of the Constitutional Court, post 1996 Constitution. The 1996 Constitution established that the exercise of public power must comply with the Constitution, making any challenge to the exercise of public power a constitutional matter. Public power, exercised by entities like the President, ministers, and state officials, is subject to constitutional review. Broader jurisdiction. The Constitutional Court can declare laws or actions unconstitutional and invalid. It has jurisdiction over disputes relating to the status, powers, and functions of organs of state. It also hears disputes arising from the interpretation and application of ordinary legislation designed to give effect to constitutional rights. 2013 Constitutional Court Amendments. The Constitution's 17th Amendment Act, 2013, expanded the jurisdiction of the Constitutional Court. Section 167(3) and now makes the Constitutional Court the highest court in all matters, not just constitutional matters. The court can hear non-constitutional matters if it grants leave to appeal based on two conditions. 1. The matter raises an arguable point of law. 2. The matter is of general public importance. The Constitutional Court has discretion to decide whether to hear an appeal, considering whether it is in the interest of justice to do so. For example, Paulson v. Slipknot Investments. Limitations. The Constitutional Court cannot hear appeals based solely on factual disputes. In non-constitutional matters, the court can decide whether to hear the case if the two conditions are met, but it is not obligated to hear the case. Case law and jurisdiction. Paulson v. Slipknot Investments emphasized that the court must consider whether it is in the interests of justice to hear the appeal, even if the matter raises an arguable point of law. Exclusions. The Constitutional Court does not have jurisdiction over matters based purely on factual disputes or those that do not raise constitutional questions, or issues that do not require the court to interpret or develop the law in line with the Bill of Rights. Next. Page The distinction between factual disputes and disputes about points of law. Case, S. v. Bozak. Facts: Bozak was convicted on fraud and theft charges. The SCA dismissed his appeal on most charges, but reduced the sentence. Bozak appealed to the Constitutional Court, claiming the SCA wrongly interpreted the facts and violated his right to be presumed innocent under Section 35(3)(h) of the Bill of Rights. Constitutional Court's finding. The Constitutional Court held that Bozak was essentially contesting factual findings, which is not a constitutional issue. Principles identified. A. Factual disputes. Disagreements over factual findings by the SCA do not constitute a constitutional matter. The Constitutional Court cannot entertain appeals based solely on factual disputes. B. Common law development. If the SCA develops or fails to develop a common law rule in a manner inconsistent with constitutional obligations, it may raise a constitutional matter. C. Application of legal rules. The application of a legal rule by the SCA can raise a constitutional issue if it conflicts with constitutional rights or principles. Jurisdiction of the Constitutional Court. Concurrent jurisdiction. The Constitutional Court, High Courts, and SCA have concurrent jurisdiction on direct challenges to the constitutionality of legislation. If a High Court or SCA declares legislation unconstitutional, the Constitutional Court must confirm the invalidity before it takes effect. This ensures consistency across jurisdictions. Exclusive jurisdiction. The Constitutional Court has exclusive jurisdiction on certain matters, including disputes between organs of state, for example, national versus provincial governments, regarding their constitutional status, powers, or functions. Constitutionality of bills. The Constitutional Court has exclusive jurisdiction to assess the constitutionality of parliamentary or provincial bills referred to it by the President or a Premier under Sections 79 or 121. Applications by legislators. The Court has exclusive jurisdiction to decide on the constitutionality of acts of Parliament or provincial legislatures referred by at least one-third of members of the National Assembly or 20% of provincial legislature members. Key case: Women's Legal Trust v. President of the Republic of South Africa. The Constitutional Court's exclusive jurisdiction is grounded in its political legitimacy, and it has specific competencies involving its constitutional role, especially in disputes between organs of state. Time frame for legislative review. Constitutional Court must hear applications to declare an act invalid within 30 days of the President or Premier assenting to the act. Next page. Exclusive jurisdiction of the Constitutional Court. Constitutional amendments. The Constitutional Court has exclusive jurisdiction to determine the constitutionality of any amendment to the Constitution. Case: United Democratic Movement v. President of the Republic of South Africa. Amendments passed in accordance with the manner and form requirements of Section 74 of the Constitution become part of the Constitution. Once amendments become part of the Constitution, they cannot be challenged for inconsistency with other constitutional provisions. The Constitution, as amended, must be read as a whole, with its provisions interpreted in harmony. Challenges to amendments are limited to whether the correct procedure was followed, not the substantive constitutionality. Example: amendments that affect Section 1, the supremacy of the Constitution, must be passed with a 75% majority in the National Assembly. Failure to meet this requirement could lead to the invalidation of the amendment. Radical amendments and basic structure. Case: Premier of KwaZulu-Natal and others v. President of the Republic of South Africa. Obitter remarks, if an amendment radically restructures the fundamental premises of the Constitution, it may not qualify as an amendment and could be challenged. Any substantial change to Section 1 would require a 75% majority and could potentially be challenged in the Constitutional Court. Failure to fulfill constitutional obligations. The Constitutional Court has exclusive jurisdiction to determine whether the President or Parliament has failed to fulfill a constitutional obligation. The phrase "fulfill a constitutional obligation" should be narrowly construed to avoid conflict with Section 172(2)(a), which grants other courts jurisdiction over the validity of presidential acts or acts of Parliament. Case: Economic Freedom Fighters v. Speaker of the National Assembly. The Constitutional Court ruled that if both the President and National Assembly breach their constitutional obligations, it may still entertain the application against both if the issues are of high political importance with far-reaching implications for governance. The breach of obligations is inseparable between the President and the National Assembly. The issues at stake are grave and require expeditious resolution in the national interest. Next page. Exclusive jurisdiction of the Constitutional Court. Certification of Provincial Constitution. Section 144 of the Constitution grants the Constitutional Court exclusive jurisdiction to certify a provincial constitution. Direct access to the Constitutional Court. Section 167(6) allows direct access to the Constitutional Court, even in cases where it does not have exclusive jurisdiction, if the court determines that it is in the interest of justice. Direct access is an extraordinary procedure, granted only in exceptional cases where compelling reasons justify bypassing lower courts. The Constitutional Court is generally reluctant to grant direct access as it is not in the interest of justice for the court to act as a court of first and last instance. Factors for granting direct access. The urgency of the case. The benefit of decisions from lower courts. Avoiding deciding complex constitutional or factual issues without lower courts' input. Case, Bruce and another v. Fleecitex Johannesburg CC and others. The court highlighted the importance of lower courts' judgments in cases with disputed facts or non-decisive constitutional issues. Role of the Supreme Court of Appeal, SCA, 17th Amendment of the Constitution. The 17th Amendment has redefined the jurisdictional roles by affirming the Constitutional Court as the highest court, especially for constitutional and legal doctrine matters. The SCA is no longer the highest court for non-constitutional matters. The Constitutional Court has jurisdiction over constitutional matters and any other matter if it grants leave to appeal on general public importance. Amendments to Section 167. Section 167(3) makes the Constitutional Court the highest court for all points of legal doctrine. Section 167(3)(b) allows the Constitutional Court to decide on non-constitutional matters by granting leave to appeal, depending on their public importance. The Constitutional Court has the final say on its jurisdiction, providing more control over its caseload. Impact on the SCA. The SCA no longer serves as the highest court for non-constitutional matters, diminishing its role and influence in legal matters that do not involve disputes of fact. Section 39(2) of the Constitution allows the Constitutional Court to address matters regarding common law, customary law, and legislation within the framework of the Bill of Rights, potentially impacting the SCA's function. While the amendments reduce the status of the SCA, it is yet to be determined how much its jurisdiction will be affected, particularly in non-constitutional matters. Next page. Supreme Court of Appeal, SCA, and Constitutional Matters. Jurisdiction of SCA. Interim Constitution. The SCA was the final court for non-constitutional matters, while the Constitutional Court had final jurisdiction on constitutional matters. 1996 Constitution. The SCA gained jurisdiction to hear and decide constitutional matters and is now empowered to hear appeals from the High Court in constitutional cases. Constitution 17th Amendment Act. The SCA remains the final court for non-constitutional issues, except where the Constitutional Court decides to hear an appeal on grounds of public importance. The SCA is the final court for factual findings and ordinary appeals relating to non-contested legal rules. Direct appeal to Constitutional Court. When a case raises constitutional issues but does not involve the development of the common law or customary law, an appeal may be made directly from the High Court to the Constitutional Court to reduce time and costs. In common law development cases, the SCA will usually first consider the matter due to its expertise, as confirmed in Masia v. Director of Public Prosecutions Pretoria. Case, Ahmad v. Multilateral Motor Vehicle Accidents Fund. The SCA has the jurisdiction to develop the common law, even in constitutional matters. SCA's role. Its views on the development of common law are crucial for constitutional matters that involve common law development. High courts in constitutional matters. High court jurisdiction. The high courts have broad jurisdiction over constitutional matters, except those reserved for the Constitutional Court or other designated courts. Most constitutional cases are first heard in a high court. Declaration of invalidity. If a high court declares any law invalid, it must be confirmed by the Constitutional Court before having any force. If a high court refuses to declare legislation invalid, there is no automatic referral to the Constitutional Court. The party seeking invalidity must appeal to the Constitutional Court. Magistrates' courts and constitutional matters. Jurisdiction of magistrates' courts. Magistrates' courts cannot hear constitutional matters. Section 170. Magistrates' courts may only decide matters assigned by Acts of Parliament, but they cannot rule on the constitutionality of laws or presidential conduct. Magistrates' Courts Act. Section 110(1). confirms that magistrates' courts cannot rule on the validity of laws or conduct of the President. Section 110(2). If an issue of constitutionality arises, the magistrate must assume the law or conduct is valid, and the litigant must approach the High Court. Next page. 6.4 The independence of the superior courts. 6.4.1 Introduction. Transition to democracy. South Africa's shift to an open and democratic society relied heavily on the establishment of an independent judiciary to protect fundamental rights and ensure that government actions adhere to the law and constitutional values. Judiciary under apartheid. The judiciary, despite being deeply influenced by apartheid, played a critical role in South Africa's democratic transition. Under apartheid, the judiciary was predominantly white and male, with its involvement in interpreting and enforcing apartheid laws. However, after the transition, no judges were removed, and the judiciary retained and even expanded its powers. Creation of the Constitutional Court. The Constitutional Court was created to handle constitutional matters exclusively, making it the final arbiter in these cases, marking a significant departure from the past. Constitutional Court's importance. The court's creation was a pragmatic and principled decision to enhance the legitimacy of the judiciary and ensure it was impartial, especially in the context of its historical ties to apartheid. Restoring judicial independence. The Constitutional Court played a key role in restoring the independence of the judiciary. It represented a fresh start, acting as the guardian of the constitutional values and ensuring the independence and impartiality of the judiciary post-apartheid. The judiciary's independence was bolstered by retaining the existing court structure and safeguarding the tenure of judges who were appointed before 1994. Next page. Should South Africa have followed the Kenyan model of vetting old order judges? Kenyan vetting process. Introduction. When Kenya adopted its 2010 constitution, it faced a challenge with a judiciary thought to be corrupt and politically compromised. The Kenyan constitution established a vetting process, where an independent board of experts assessed judges' integrity. Only those judges who passed the vetting process retained their positions. Those implicated in corruption or lack of impartiality were removed. The aim was to re-establish the credibility and integrity of the Kenyan judiciary. South African approach. Retention of judges. South Africa chose not to follow the Kenyan vetting model. Judges from the apartheid era retained their positions. Section 174(1) of the South African Constitution provides that only fit and proper persons can be appointed as judicial officers, while Section 174(2) stresses the importance of reflecting racial and gender diversity in judicial appointments. The process focused on gradual transformation through new appointments as older judges retired, rather than removing those who served during apartheid. Question of legitimacy. Was South Africa's model wise? Some question whether the South African model, which emphasizes gradual transformation, was the right choice, especially regarding legitimacy. Given the judiciary's importance to South Africa's democratic legitimacy, should the country have vetted old order judges to ensure greater public trust? Judicial independence and impartiality. Judicial independence. Judicial independence is central to a constitutional democracy, ensuring that courts are free from outside influence. This is key in safeguarding the impartiality and integrity of the judiciary. Impartiality. Impartiality is the ability of judges to interpret and enforce the law without bias, not influenced by personal views, ideology, or political beliefs. However, interpreting the Constitution is complex due to its open-ended language. Judges often reference contextual factors and extra-legal texts when interpreting the Constitution. South African courts, including in Kentridge J's first judgment, recognize the complexity of maintaining impartiality given the broader context of interpretation. Despite this, judges are expected to remain neutral and avoid personal biases. Sarafutu case. The Sarafutu case affirmed the importance of impartial adjudication, insisting that judges should disregard personal beliefs and political predispositions during judicial decision-making. Even though interpreting the Constitution requires considering broader contexts, the court emphasized the need for objectivity. Conclusion. South Africa's judicial model. The South African model of gradual transformation, rather than immediate vetting, reflects the country's emphasis on continuity in the judiciary while managing the transition. While Kenya's model offered a more direct means to address potential judicial corruption and compromise, South Africa's model aimed to maintain judicial stability while fostering transformation through new appointments. Next page. The test for judicial independence. S. and others v. Van Rooyen and others, General Counsel of the Bar of South Africa intervening, judicial independence. The Constitutional Court affirmed that judicial independence requires judges to hear and decide cases without external interference. Judges must act impartially, and at an institutional level, there must be structures in place to protect judges from external pressure. Hierarchical differences. There are hierarchical differences between higher and lower courts, which influence the level of judicial independence required. Lower courts do not need the same level of protection as higher courts, as their jurisdiction is more restricted and they do not deal with constitutional matters. However, lower courts are entitled to protection from higher courts if their independence is threatened. Objective test for independence. Test for independence. The test for judicial independence is whether, from the perspective of an objective, reasonable, and informed person, the court or tribunal enjoys the essential conditions of independence. Public confidence is crucial. Without this confidence, the justice system cannot command respect and acceptance, which are essential for its effectiveness. The objective test considers whether a reasonable person would perceive the judge as impartial and independent. Apprehension of bias must be reasonable, based on the facts of the case and the information available. Contextualization. The perception must be based on a balanced view of all relevant information. The perception is not from a hypersensitive, cynical, or suspicious observer, but a well-informed, thoughtful, and objective one, sensitive to South Africa's social realities and constitutional values. Implications for the independence of judges. Impartiality and independence. Judges may not always be able to be completely impartial due to pressures and the conditions under which they work. Independence is only meaningful if judges can operate without fear or favor, and if the judiciary is functionally independent from other branches of government. Judges must be free from direct and indirect pressures from the state or private actors. Structural safeguards. Structural safeguards are necessary to ensure judicial independence. These safeguards protect judges from external influence, both governmental and private. This aspect of independence emphasizes the judiciary's role in checking the arbitrary or unjust exercise of power. Courts must not be constrained by fear or practical difficulties when carrying out their judicial role. Functional independence. Judicial independence involves a distinct and discrete role for the judiciary, free from political, financial, or social pressures. Judges must have the autonomy to regulate the legality of state actions, enact justice, and uphold constitutional values. Chaskalson C.J.'s view. In Van Rooyen, Chief Justice Chaskalson argued that judicial independence is constitutionally protected for all courts, regardless of their hierarchical status. The judiciary's independence involves maintaining a separation from other branches of government, which is fundamental for ensuring the core values of the judiciary are upheld. Conclusion. Structural independence of superior courts. To determine whether courts are structurally independent, factors such as the appointment process, safeguards against external pressures, and functional autonomy must be assessed. Magistrates' courts, which do not handle constitutional matters, are excluded from this analysis, focusing instead on the superior courts. Next. Page 6.4.2 Appointment of judges. Historical context. Before 1994, political considerations influenced the appointment of judges, potentially affecting their impartiality and independence. The Constitution drafters had to balance the need for judicial independence with the reality that judicial decisions often have political consequences, especially when courts can declare acts of Parliament or the executive invalid. Compromise in the appointment process. The appointment of judges could not be fully insulated from the political process, as it might delegitimize the judiciary and make it difficult to strike down legislation and executive actions. However, leaving the appointment solely in the hands of the president or elected politicians could lead to party political considerations dominating, thus undermining judicial independence and impartiality. Judicial Service Commission, JSC. The JSC was created as a compromise to ensure both political involvement and judicial independence. The JSC plays a fundamental role in the appointment of all superior court judges, with varying degrees of involvement depending on the judicial position. Section 178 of the Constitution and the JSC Act established and regulate the JSC. Composition of the JSC. The JSC comprises 23 members, representing a mix of judiciary, legal profession, legislature, executive, civil society, and academia. The Chief Justice chairs the JSC. Of the 23 members, 15 represent political interests, including Minister of Justice, 6 members of the National Assembly, 3 from minority parties, 4 members of the National Council of Provinces, NCOP, with a majority party representation. 4 presidential nominees. Legal professionals, attorneys and advocates, are also represented. Role and importance of the JSC. The Constitutional Court has emphasized the importance of the JSC in appointing judges and the need for members to take the task seriously. Judges must be appointed based on qualifications and their ability to fulfill their constitutional duties. The court stresses that the judicial appointment process must attract candidates who are best suited to serve, acknowledging that bad appointments have occurred but should not define the process. Appointments and decision-making for specific high courts. The Premier of the province and the Judge President of the province are involved when the JSC deals with matters relating to a specific high court, including the appointment or disciplining of judges. If the Premier is absent during these discussions, the JSC's decision will be considered invalid. Next page. Appointment process for judges. Vacancy procedure. When a vacancy arises, the Chief Justice, as chairperson of the JSC, calls for nominations. Shortlisted candidates are publicly interviewed. The JSC then makes recommendations to the President for appointment. Public versus transparency. Interviews are public, a departure from the secretive process during the apartheid era. However, there is criticism regarding the lack of transparency in the selection criteria used by the JSC. JSC deliberations are often kept confidential, leading to concerns that the reasons for preferring one candidate over another are not always clear. The interview process has been criticized for not allowing candidates to discuss their judicial philosophy, commitment to legal transformation, and approach to adjudication. Helen Suzman Foundation v. Judicial Service Commission. The Constitutional Court confirmed that, if a decision about judicial appointments is challenged, the JSC must provide reasons for the decision. Transcripts of interviews, applications, professional body comments, and related research and submissions. Deliberations of the JSC should also be disclosed, especially in the event of a legal challenge. The JSC's argument that secrecy ensures candid deliberations and prevents potential embarrassment of candidates was rejected. The court argued that inappropriate comments should not be made if deliberations are conducted properly. This ruling may lead to more careful deliberations by the JSC, as members may now be aware that their statements could be disclosed in future legal challenges. Consultation for key appointments. Chief Justice and Deputy Chief Justice appointments. The President, as the head of the executive, has wide discretion but must consult the JSC and leaders of opposition parties in the National Assembly before deciding on the appointment. The final decision remains the President's. President and Deputy President of the SCA. The President appoints after consulting the JSC, but no consultation with opposition party leaders in the National Assembly is required. Consultation process. Consultation must occur before the appointment, and any post-decision consultation is unlawful. Consultation requires a good faith exchange of views, although it does not mean that the President must follow the advice of those consulted. Other Constitutional Court judges. The President appoints the remaining Constitutional Court judges after consulting the Chief Justice and leaders of parties in the National Assembly. The JSC plays a more involved, though not decisive, role in these appointments. Next page. Appointment of judges, process and criteria. Nomination and appointment process. The JSC must provide a list with 3 names more than the number of appointments to be made, which is then submitted to the President. The President can make an appointment from the list or refuse to appoint a candidate, provided that reasons for refusal are given. If the President rejects a nominee, the JSC must supplement the list with additional candidates, and the President must appoint from this augmented list. For example, if there is a vacancy on the Constitutional Court and the JSC submits a list of 4 candidates, the President may reject a candidate and ask for a more diverse list, for example, with candidates from different racial or gender backgrounds. Appointments to the Constitutional Court. The JSC and President must ensure that at least 4 members of the Constitutional Court were judges at the time of their appointment to the court. Appointments to the SCA and other courts. The JSC plays a decisive role in the appointment of all other judges to the SCA, high courts, and specialized courts. For these appointments, the President must appoint candidates selected by the JSC, without discretion. Criteria for selection of judges. The Constitution sets 2 essential criteria for judicial appointments. 1. The candidate must be appropriately qualified. 2. The candidate must be a fit and proper person. For Constitutional Court judges, candidates must also be South African citizens. Additional criteria. The JSC has developed further criteria for consideration. 1. Integrity of the candidate. 2. Energy and motivation for the role. 3. Competence, including technical competence, ability to uphold the values of the Constitution. 4. Experience, including technical experience, experience related to the values and needs of the community. 5. Potential for further growth. 6. Symbolism, considering the message the appointment sends to the public. Ideal qualities of a judge. The Constitution demands judges to be independent, protect the Constitution, uphold rights, and apply the law impartially. Chief Justice Mohammed emphasized qualities like scholarship, experience, dignity, rationality, courage, and intellectual integrity. The ability to weigh competing rights and exercise wisdom and humility. Chief Justice Mogoeng described key traits as a track record of fair-mindedness, commitment to human rights, rule of law, decisiveness, humility, and personal independence. Next page. Key aspects of judicial selection. Commitment to constitutional values. Constitutional values, for example, human dignity, equality, human rights, are central to judicial appointments. Candidates should be assessed for their commitment to the transformative goals of the Constitution. Judicial independence must be maintained, ensuring selectors assess values without delving into political commitments. Transformation of the judiciary. The judiciary must reflect South Africa's racial and gender composition, as mandated by Section 174(2) of the Constitution. The need for transformation arises from historical exclusion of women and racial minorities from the judiciary, particularly under apartheid. Ongoing racial and gender prejudices that must be addressed in the appointment process. Ensuring the judiciary is legitimate and fair in its representation of South African society. Diversity on the bench is argued to improve the quality of justice, as judges from diverse backgrounds bring different perspectives. Enhancing jurisprudence. Interpretation of Section 174(2). Debate exists over whether racial and gender considerations should be the primary or decisive factor in judicial appointments. The JSC sometimes prioritizes representativity, particularly when appointments are seen as crucial for addressing racial imbalance. Balancing diversity with constitutional values remains a complex issue in judicial selection. Judicial review of JSC's decisions. The JSC's decisions, including appointments, are subject to judicial review for legality and rationality. Reasoned decisions are necessary for transparency and accountability. The SCA affirmed this principle in Judicial Service Commission v Cape Bar Council. The JSC must ensure its actions are non-arbitrary and align with constitutional values of transparency and accountability. JSC's accountability. The JSC is bound by constitutional principles and must provide reasons for its decisions, ensuring accountability in the judicial selection process. Next page. Influence of race and gender in judicial selection. Racial and gender representativity. Easy case: if two candidates are similarly qualified, selecting one to enhance racial or gender representativity is deemed appropriate. Difficult case: when two candidates are equally qualified but one enhances representativity, the selection requires careful evaluation. The importance of racial and gender representativity must be balanced with the qualifications necessary for the bench. The qualities of each candidate, including skills and experience, should be evaluated to ensure the judiciary is equipped to perform its constitutional duties. Evaluation approach. The focus should be on objective qualifications rather than race or gender alone. Racist and sexist discourse must be avoided. Qualifications and fitness should drive the selection, not assumptions based on race or gender. Misleading assumptions. Being black or female should not automatically enhance a candidate's fitness and propriety for judicial office. While empathy or compassion may be influenced by personal experiences, for example, discrimination, these qualities do not automatically arise from race or gender. Constitutional commitment and judicial qualifications are not contingent on race or gender but on a candidate's humanity, skills, and life choices. Legitimacy of the judiciary. The legitimacy of the judiciary depends on its ability to perform its constitutional functions rather than simply accelerating racial or gender representativity. Racial and gender representativity should be prioritized but balanced with competence in fulfilling the judiciary's duties. Judicial oath of office. Oath requirements. Judges swear or affirm to be faithful to the Republic of South Africa. Uphold and protect the Constitution and the human rights it guarantees. Administer justice impartially, without fear, favor, or prejudice. The oath ensures judges will act impartially, making decisions based solely on the legal merits in line with the Constitution and the law. Impartiality and independence. The oath serves as a formal safeguard to ensure judges are independent and impartial, making decisions based on law, not personal biases. Next page. Security of tenure for judges. Independence of judges. Judges' security of tenure is crucial for maintaining their independence, ensuring they cannot be dismissed for decisions unfavorable to the government or powerful interests. Two aspects of security of tenure. 1. Fixed term or age of retirement. Judges are appointed for a fixed term or until they reach a specific retirement age. They cannot be forced to retire early. 2. Removal procedure. Judges can only be removed through a special procedure, protecting their position until their fixed term or retirement age. Section 176 of the Constitution. Constitutional Court judges serve a non-renewable term of 12 years or until they reach the age of 70, whichever comes first, unless extended by an Act of Parliament. Judges' Remuneration and Conditions of Employment Act, Section 4, extends this term to 15 years of active service, which includes time served on other courts like the High Court or SCA. Judges must retire at age 75, regardless of active service length. Amendment to Section 176. In 2001, the Constitution was amended to allow Parliament to extend a Constitutional Court judge's term. Critics argued this watered down security of tenure and could influence judicial independence. Criticism of the Chief Justice's extension. Section 8 of the Judges' Remuneration and Conditions of Employment Act allowed the President to extend the term of the Chief Justice or the President of the SCA at the end of their term, without consulting anyone, and without limits on the number or length of extensions. This provision was challenged in Justice Alliance of South Africa v. President of Republic of South Africa and others. Court's ruling in Justice Alliance case. The Constitutional Court declared Section 8A of the Act invalid, arguing it was unconstitutional because it granted the President unfettered discretion to extend a Chief Justice's term, without needing consultation or guidelines. The power to extend a term belongs to Parliament, not the Executive, as per Section 176(1) of the Constitution. The Court emphasized that the separation of powers doctrine prohibits Parliament from delegating its legislative power to the Executive. The provision undermined judicial independence and violated the separation of powers by allowing the President to decide on judicial terms of office. Next page. Judicial independence and the Court's ruling. Section 8A violates judicial independence. The Court ruled that Section 8A of the Judges' Remuneration and Conditions of Employment Act violated judicial independence. Open-ended discretion in extending a judge's term raises reasonable apprehension that the judiciary may be influenced by the executive. It is essential that the judiciary appears to be free from external interference to maintain its legitimacy. Importance of non-renewable term of office. A non-renewable term is key to judicial independence, ensuring that judges are not influenced by renewal threats or inducements. Section 176(1) of the Constitution affirms that Constitutional Court judges hold office for a non-renewable term, enhancing public confidence in the judiciary's impartiality. Extension of the Chief Justice's term. The Court determined that it would be impermissible for Parliament to extend only the Chief Justice's term. Such an extension could be perceived as a favor that may undermine impartiality and public confidence. The Constitution does not permit singling out an individual judge, including the Chief Justice, based on personal identity or position. Distinction between Section 8A and Section 4 of the Act. Section 4 allows the extension of a Constitutional Court judge's term based on objective criteria such as age or previous service, indifferently applied to all judges. Section 8A allowed unilateral discretion for the President to extend the term of the Chief Justice, making it problematic. Security of tenure and removal. Judges' security of tenure must be guaranteed, and removal from office should only happen for serious, objectively determinable reasons. Section 177 of the Constitution outlines the conditions under which a judge may be removed. Incapacity. Gross incompetence. Gross misconduct. Next page. Judicial removal and complaint procedures. Judicial removal process. Section 177 of the Constitution ensures that a judge cannot be arbitrarily removed for political or non-performance related reasons. After a finding by the JSC, Judicial Service Commission, that a judge is unfit for office, the National Assembly, NA, must pass a resolution for removal with a 2/3 majority. President's role. Once the NA passes the resolution, The President must remove the judge. The President may suspend the judge based on the JSC's advice while an investigation is conducted. Judicial Complaints and Investigation. The Judicial Conduct Committee, a subcommittee of the JSC, is responsible for investigating complaints against judges. The committee consists of the Chief Justice, Deputy Chief Justice, and 4 judges, at least 2 must be women. The committee can handle serious complaints that could lead to dismissal. Less serious complaints, which may be handled by referring to the head of the court. Complaints can be dismissed if they are frivolous or without substance. They are solely related to the merits of a judgment. They are hypothetical in nature. The committee may refer valid complaints to the Judicial Conduct Tribunal for a more thorough investigation. Judicial Conduct Tribunal. The tribunal consists of 2 judges, one designated as president by the Chief Justice, and a layperson. The tribunal investigates serious complaints, conducts hearings with witnesses, and submits its findings to the JSC. Based on the tribunal's findings, the JSC will decide whether to recommend impeachment to the NA. Duty of the JSC. In Freedom Under Law v. Acting Chairperson, Judicial Service Commission and others, the SCA ruled that the JSC must investigate serious complaints and cannot abandon its constitutional duty to do so. The JSC's failure to investigate a complaint against Judge President John Clope was declared unlawful. The SCA rejected the JSC's reasoning that the conflict of testimony between Clope and 2 constitutional court judges justified not proceeding with a full investigation. SCA's ruling on JSC's duty. The SCA emphasized that allegations must be investigated thoroughly and rationally. The JSC must ensure cross-examination in cases of disputed testimony. Rejecting a judge's version without this opportunity is irregular. The SCA also criticized the JSC for applying the criminal standard of proof beyond a reasonable doubt to dismiss the complaint prematurely. The case confirmed that the JSC is obligated to make a decision on complaints, and cannot decide not to act. These processes reinforce the independence of the judiciary and the constitutional protections in place to ensure that judges are not removed without a fair investigation. Next page. Financial security of judges. Judicial independence and security. Judges must be financially secure to make decisions free from fear of retaliation or prejudice. The Constitution guarantees that judges' salaries, allowances, and benefits cannot be reduced, ensuring their financial independence. The Judges' Remuneration and Conditions of Employment Act governs the conditions of service for judges, including salary determination. The President determines the judge's salary annually, based on recommendations from the Independent Commission for the Remuneration of Public Office Bearers. After publication, the salary proclamation must be submitted to Parliament, which may reject it, rendering the proclamation invalid. Judges' salaries are paid directly from the State Revenue Fund, not through any government department's allocation, reinforcing the separation from the executive branch. Limitation of civil liability. Judicial immunity. Judges must be protected from civil liability for actions taken during their judicial functions to maintain independence. Penrice v. Dickinson established that judges are not liable for delictual damages unless they act with malice. May v. Edwin confirmed that judges can raise the defense of qualified privilege in defamation actions. A judge is only liable for defamatory statements if it's proven they acted with personal spite, ill will, or an improper motive. Without such protection, judges could face numerous defamation suits, hindering their judicial duties. Historical protections. Before the Superior Courts Act, Section 25(1) of the Supreme Court Act prohibited civil actions or subpoenas against Supreme Court judges without court permission. Constitutional Court judges also enjoyed similar protections under the Supreme Court Act, requiring the Chief Justice's consent before civil proceedings could be initiated against them. These protections were not carried over into the Superior Courts Act, but the principle of judicial immunity remains. Office of the Chief Justice. Role of the Chief Justice. The Constitution designates the Chief Justice as the head of the judiciary, responsible for establishing norms and standards for judicial performance across all courts. The Chief Justice oversees various administrative functions, traditionally supported by the executive branch, raising concerns about judicial independence. Establishment of an independent office. In 2010, the Office of the Chief Justice was proclaimed a national department under the Public Service Act to enhance judicial independence. The Superior Courts Act, 2013, further strengthened the office by defining the Chief Justice's powers as head of the judiciary, establishing the Secretary General as the head of the office. In 2015, The administration of the superior courts was transferred from the Department of Justice to the Office of the Chief Justice, ensuring a clearer separation between the executive and the judiciary. Next page. Independence of the lower courts and traditional courts. 6.5.1 Lower courts under the interim constitution. Magistrates' courts pre-1993. Before 1993, magistrates' courts had minimal independence. Magistrates and regional magistrates were public servants under the Department of Justice and were typically promoted from public prosecutors. As public servants, magistrates were subject to disciplinary actions under the Public Service Act, leading to concerns about undue executive influence and a lack of judicial independence. Hoekstra Commission, 1983. Recommended legislative reforms to enhance the independence of magistrates and reduce executive control. Magistrates Act, 1993. Removed magistrates from the public service, establishing a magistrates' commission to handle their conditions, appointments, and dismissals. The Magistrates' Commission had an advisory function in magistrate appointments, but the executive retained discretion over appointments. The Magistrates Act was passed during a period of non-representative governance, with the Magistrates' Commission lacking broader public representation, as it was controlled by predominantly white judicial bodies. Section 109 of the Interim Constitution constitutionalized the Magistrates' Commission, mandating it to ensure independent and unbiased judicial processes. 6.5.2 Independence of the lower courts under the 1996 Constitution. Judicial authority in the 1996 Constitution. The 1996 Constitution grants judicial authority to the courts, including magistrates' courts. Section 166d. Section 174(7) mandates that the appointment, promotion, transfer, dismissal, and disciplinary actions for magistrates must be conducted without favor or prejudice. Absence of a magistrates' commission in the Constitution. The 1996 Constitution did not include a provision for a magistrates' commission like the Judicial Service Commission, JSC, for judges. During certification, objections were raised regarding the absence of a magistrates' commission and the lack of explicit provisions on the appointment, term of office, remuneration, and removal of magistrates. The Constitutional Court confirmed that the independence of the courts under Section 165 suffices to ensure judicial independence, and the Act of Parliament governing magistrate appointments must comply with constitutional control to avoid undermining this independence. Recomposition of the Magistrates' Commission, 1996. Following constitutional amendments in 1996, the composition of the Magistrates' Commission was modified to be more representative of South African society, addressing historical racial and gender imbalances in the legal profession. The Van Rooyen case emphasized that the changes reflected the transformation of South Africa, aiming to align the Commission with the principles of racial and gender equality as committed to in the Constitution. Current composition of the Magistrates' Commission. The Magistrates' Commission now includes a mix of 1 judge, 6 magistrates, 4 legal practitioners, 1 law teacher, 8 members of Parliament, 5 executive nominees. The Minister and the head of Justice College are also members. The Constitutional Court noted the diversity within the Commission, which mirrors the composition of the JSC. Functioning of the Commission. The Magistrates' Commission does not conduct interviews but compiles a list of candidates for magistrate positions from trained and exam-passing public prosecutors. The same commission that sets judicial salaries also determines magistrate remuneration. Next page. Independence of traditional courts. 6.5.3 Traditional courts in South Africa. Legal foundation. Traditional courts in South Africa are primarily governed by customary law and historical apartheid-era laws, notably the Black Administration Act, BAA. The authority of traditional courts is derived from Sections 12 and 20 of the BA, Section 16 of Schedule 6 of the Constitution. Chapter 12 of the Constitution acknowledges the institution, status, and role of traditional leadership under customary law, subject to other constitutional provisions. Despite being an apartheid-era law, the BA still governs traditional courts, although most provisions of the Act have been repealed. Jurisdiction and structure. The Minister has the power to confer civil and criminal jurisdiction on chiefs, headmen, or their deputies. Customary law does not outline a clear hierarchy for traditional courts, and there is no appeal process from a headman's court to a chief's court. Cases typically progress as follows. Start at family councils. If unresolved, Move to Headman's Court. Appeal to the Chief's Court. Magistrates' Court handles further appeals. Chiefs are hereditary leaders, not elected, which contrasts with modern democratic principles. Composition of traditional courts. The BA does not prescribe the composition of traditional courts. Chiefs or headmen are the central figures in these courts, often presiding with the help of advisors. Female participation in these courts is typically limited, as traditional leadership roles have historically been male-dominated. The role of the presiding officer is often less formal than in modern court systems. Counselors or trusted advisors usually preside, and decision-making is collective. Nature of traditional courts. Traditional courts are considered non-professional and community-based, where community members actively participate in the judicial process. The concept of a single presiding officer is often irrelevant, as decision-making is typically collaborative, with decisions reflecting the collective views of the community. Customary law's flexibility means there is no standard, unified system governing traditional court operations, varying between communities. Concerns on judicial independence. Traditional courts face challenges regarding their independence, particularly since traditional leaders also exercise executive and legislative powers, leading to potential conflicts of interest. Courts have had differing views on whether traditional courts can meet the judicial independence requirements set by the Constitution. The Constitutional Court has not yet ruled on the compatibility of traditional courts with constitutional principles of judicial independence. Criminal versus civil jurisdiction. There are arguments for distinguishing between civil and criminal matters within traditional courts. Civil cases. Traditional courts are seen as providing effective access to justice for rural communities, which might not require the same level of independence as criminal cases. Criminal cases. Concerns arise where the presiding officer may also play roles like complainant, prosecutor, and judge, which could compromise fairness and independence. Some scholars, like Bennett, argue that traditional courts should retain civil jurisdiction but not handle criminal matters, ensuring justice while maintaining judicial independence. Next page. National Prosecuting Authority, NPA 6.6 Overview of the NPA, Context of Creation. During the 1996 Constitution negotiations, many apartheid-era personnel within the prosecuting authority remained in their roles, leading to concerns from the ANC about potential bias or opposition to the new government. The old guard of prosecutors, under apartheid-era legislation, had the power to exercise discretion in criminal proceedings without interference from the executive. This autonomy raised concerns about the abuse of power. The ANC, wary of these potential abuses, pushed for the establishment of a unified and independent National Prosecuting Authority, NPA, to ensure the prosecution system would not be influenced by political or executive powers. 6.6.1 Establishment and Structure of the NPA, Section 179 of the Constitution. Created a single National Prosecuting Authority, led by the National Director of Public Prosecutions, NDPP. The NDPP holds the ultimate authority to direct prosecutions across South Africa. Provincial Directors of Public Prosecutions, DPP, handle prosecutions within their areas but remain under the NDPP's jurisdiction. Deputy National Directors share countrywide prosecutorial jurisdiction and must follow the NDPP's directions. 6.6.2 Powers of the NDPP. Authority over prosecuting powers. The NDPP has authority over the powers and duties of all members of the prosecuting authority, as defined by the NPA Act and the Constitution, Section 22(1). The NDPP's power includes setting prosecution policy, which must be determined in consultation with the Minister of Justice and the provincial DPPs. The minister's concurrence is required before the policy is enacted, allowing the minister to veto the NDPP's policy. Prosecution policy. The NPA's prosecution policy contains general principles rather than strict guidelines, providing flexibility for prosecutors in deciding when to initiate prosecutions. The policy incorporates a discretionary power for prosecutors, applying evidential and public interest tests when deciding on prosecutions. 6.6.3 Intervention and review powers of the NDPP. Intervention in prosecution decisions. The NDPP can intervene if prosecutorial decisions do not follow the established policy directives. Additionally, the NDPP can review decisions to prosecute or not prosecute, even when the guidelines are followed, after consulting with the relevant DPP and taking representations from the accused, complainant, and other relevant parties. This broad discretion allows the NDPP to assess the appropriateness of prosecution decisions, as demonstrated in the discontinuation of President Jacob Zuma's prosecution. Limitations. The NDPP's intervention power is confined to reviewing prosecution decisions rather than influencing the conduct of a case in court. Procedural safeguards ensure that the NDPP cannot exercise these powers without proper consultation. If procedural requirements are not met, a court can review and potentially set aside the decision, leading to the reinstatement of charges. 6.6.4 Impact and Significance. Independence of the NPA. The establishment of the NPA was a critical move to ensure the independence of prosecutorial decisions from executive control and protect the prosecuting authority from potential abuse. Despite the requirement for the minister's concurrence on prosecution policy, the NPA's overall autonomy remains strong due to the NDPP's broad discretion to review prosecutorial decisions. The NPA's role in shaping the fairness and impartiality of prosecutions is essential for maintaining public confidence in the justice system. Next page. Independence of the National Prosecuting Authority, NPA 6.6.5 The NPA's powers and its independence. Constitutional Court's emphasis. The Constitutional Court underscored the extensive powers of the National Director of Public Prosecutions, NDPP, highlighting their crucial role in criminal justice. Any erosion of the independence of the NPA poses a serious risk to democracy, potentially allowing those in power to avoid prosecution. In the case of Corruption Watch NPC and others v. President of the Republic of South Africa and others, the court stressed that a corrupt or dysfunctional prosecuting authority undermines the rule of law, a fundamental value of the Republic, and contradicts the constitutional mandate to prosecute without fear, favor, or prejudice. 6.6.6 Disagreement on the nature of independence. Conflicting provisions. While the Constitution vests prosecutorial responsibility in the NPA, it also requires the Minister of Justice to exercise final responsibility over it, creating potential tension between the NPA's independence and the minister's oversight role. The Supreme Court of Appeal, SCA, noted that these provisions might appear conflicting but are not incompatible. It cited a Namibian Supreme Court ruling, affirming that the minister cannot direct the NPA to prosecute or decline prosecutions but must be kept informed about significant cases. 6.6.7 Key provisions of the National Prosecuting Authority Act. Impartiality and independence. The NPA Act mandates that members of the NPA must act impartially, carrying out their duties in good faith, and free from fear, favor, or prejudice. Interference with the NPA's work is prohibited. Any improper interference is punishable by up to 10 years imprisonment. The Minister of Justice has limited oversight powers. They can require reports from the NDPP on specific cases, but they cannot influence prosecutorial discretion in individual cases. Minister's oversight role. The minister can approve prosecution policy and request information on any case. However, prosecutorial discretion regarding specific cases is beyond the minister's authority. The SCA confirmed that the NPA must be non-political and non-partisan, aligning it with the broader function of the judiciary to deliver criminal justice. 6.6.8 Presidential appointment of the NDPP. Appointment process. The President has broad discretion in appointing the NDPP and other directors of public prosecutions, but appointees must have legal qualifications and be fit and proper persons. The NDPP is appointed for a non-renewable term of 10 years. The President must consult the Minister of Justice before appointing deputy national directors and directors. Constitutionality of appointment. The first certification judgment addressed concerns about the separation of powers. The Constitutional Court rejected the objection that the NDPP's appointment process violated the separation of powers principle but emphasized that Section 179 guarantees the independence of the NPA. 6.6.9 Constitutional guarantees of independence. Section 179 of the Constitution guarantees that national legislation ensures that the NPA exercises its functions without fear, favor, or prejudice. Any inconsistent legislation or executive actions are subject to constitutional control by the courts. Independence is a constitutional requirement that cannot be undermined by legislation or executive interference. Underscore. These sections confirm the critical independence of the NPA to safeguard criminal justice in South Africa, preventing political or executive interference in prosecution decisions. Next page. Appropriateness of the President appointing the NDPP. June 6, 2010 Presidential appointment of the NDPP. Constitutional negotiations and rejection of JSC appointment. During constitutional negotiations, the idea of the Judicial Service Commission, JSC, nominating the NDPP, with the President making the final appointment, was rejected. According to Section 179(1) of the Constitution, the President alone holds the authority to appoint the National Director of Public Prosecutions, NDPP. Criticisms of presidential appointment. The National Association of Democratic Lawyers, NADEL, argued that nothing in the Constitution or the National Prosecuting Authority Act, NPA Act, prevents the President from appointing an NDPP who may make prosecutorial decisions in favor of the President's political interests. Some commentators view this as inappropriate, citing concerns about the separation of powers and potential conflicts of interest. First certification case. In the first certification case, the argument was advanced that the President's appointment of the NDPP intrudes on the separation of powers between the executive and judiciary. The Constitutional Court rejected this argument, asserting that the President's role in appointing the head of the NPA does not violate the separation of powers. June 6, 2011 Conflict of interest concerns, Corruption Watch case of Corruption Watch v. President. The High Court ruled that President Jacob Zuma was conflicted in appointing a new NDPP due to his personal criminal charges. The court stated that conflicted persons cannot act in ways that could pervert justice, especially when a decision on prosecution might directly affect them. The court held that, in such cases, the Deputy President should act as President for decisions concerning the NDPP's appointment. Implications for future appointments. The conflict of interest in this case raised concerns about whether the President's power to appoint the NDPP would always be susceptible to political bias or personal interest, particularly when the President is politically or legally compromised. June 6, 2012 Security of tenure of the NDPP. NPA Act provisions for removal. The NPA Act includes provisions for the removal of the NDPP and directors, which can only happen after an inquiry into the individual's fitness to hold office. Grounds for removal include misconduct, ill health, incapacity, unfitness to perform duties. However, the President has significant discretion over appointing the chairperson of this inquiry and determining its terms of reference, leading to concerns about the impartiality of the process. Risk of political interference. Since the President appoints the inquiry chairperson, there is a potential for political interference, which might undermine the security of tenure of the NDPP. The provisional suspension of the NDPP or a director by the President, pending inquiry, could also be used as a means to pressure the NDPP to resign or accept a golden handshake. Parliamentary oversight. After the inquiry, Parliament must decide whether to confirm or reinstate the NDPP within 30 days of being informed of the President's decision. The President must also remove the NDPP if both houses of Parliament request it on the prescribed grounds. June 6, 2013 Concerns about political pressure. Potential for political influence. The NDPP holds extraordinary power, and individuals in politically sensitive positions, particularly politicians and businesspeople, may attempt to ensure the NDPP remains sympathetic to their interests. If an NDPP becomes too independent or fearless, they may face significant political pressure to resign or be removed from office. Security of tenure and political interference. The removal process described in the NPA Act may not offer sufficient safeguards to ensure the NDPP's security of tenure, leaving room for political interference. The fact that no NDPP has completed a full 10-year term further raises concerns about the independence and stability of the office. June 6, 2014 Alternative appointment mechanisms. JSC nomination. If the President's appointment mechanism is seen as problematic, the JSC could potentially be tasked with nominating the NDPP. However, concerns exist about whether the JSC, designed to deal with judicial matters, is well equipped to handle prosecutorial appointments. Recommendation for reform. Given the concerns about political influence, there may be a need to reconsider the appointment process and explore alternatives that would strengthen the independence of the NDPP while maintaining the separation of powers. These concerns highlight the complexity of ensuring the NDPP's independence and impartiality, and whether the current appointment and removal mechanisms provide adequate protection from political influence. Next page. Removal through payment of a golden handshake. June 6, 2015 Corruption Watch NPC v President of the Republic of South Africa and others, Nkosazana v Corruption Watch NPC. Context and issue. The Constitutional Court examined whether President Jacob Zuma unlawfully offered Mtolisi Nxashana, the then NDPP, a golden handshake to persuade him to vacate his office. The case arose from attempts to bypass the formal removal procedures in the NPA Act through informal means such as monetary settlements. Section 12(8) of the NPA Act. This section allows the NDPP to voluntarily vacate their office, but emphasizes that such a decision must be truly voluntary to preserve the independence of the office. The Constitutional Court emphasized that any act or conduct which compromises the voluntary nature of the NDPP's resignation is constitutionally invalid. Court's findings. The court found that former President Zuma pursued a series of steps to force Nxashana out, including threatening suspension pending an inquiry, proposing mediation when no progress was made, offering a R10 million settlement, which was later left open-ended to allow Nxashana to choose the amount. The court described these efforts as a clear indication of Zuma's desperation to remove Nxashana at any cost. Key points in the court's judgment. The court noted the disproportionate settlement of R17.3 million, which was much higher than the financial entitlement Nxashana would have received had his resignation been voluntary as per Section 12(8)(a). 2. Zuma's conduct was seen as undermining the independence of the NDPP, and the court suggested that this kind of buying out of NDPPs could lead to the removal of troublesome or unwanted officeholders through huge sums of money rather than adhering to formal procedures. Constitutional Court's intervention. The court affirmed its vigilance in protecting the independence of the NPA and signaled its willingness to intervene when informal attempts to subvert the independence of the office arise. The judgment reinforced the importance of following the prescribed legal procedures for the removal of the NDPP, rather than using informal, potentially coercive measures such as golden handshakes. June 6, 2016 Implications for NDPP independence. Erosion of NDPP independence. The Corruption Watch judgment highlighted how the independence of the NDPP can be eroded not only through direct political pressure but also through financial incentives or threats. The offering of golden handshakes as a means to induce voluntary resignation risks compromising the integrity and impartiality of the NDPP, making the office vulnerable to external influence. Constitutional safeguards. The judgment emphasizes the need to ensure that any vacation of office by the NDPP remains voluntary and not influenced by improper or coercive external forces, such as the promise of a large financial settlement. The Constitutional Court stressed that attempts to bypass formal procedures for removal through informal settlements would be met with judicial scrutiny to protect the independence of the office. Next page. Summary. Judiciary and separation of powers. The judiciary is the third and most independent branch of government within the separation of powers framework. The Constitutional Court is the highest court, with jurisdiction to hear constitutional matters and any significant legal issue that it deems important. It typically acts as an appellate court but has original jurisdiction in cases where a high court declares an act of parliament, provincial law, or presidential act invalid. Exclusive jurisdiction of the Constitutional Court includes disputes between state organs, constitutionality of laws, and failure of Parliament or the President to fulfill constitutional obligations. Superior Courts. The Supreme Court of Appeal, SCA, is an appellate court that handles matters except those reserved for the Constitutional Court, and it is the final court on factual and legal findings. The high courts can hear constitutional matters, except those exclusive to the Constitutional Court, and they often serve as courts of first instance. Role of the judiciary. The judiciary ensures that the government branches act in accordance with the Constitution. Judicial independence is safeguarded by mechanisms such as the Judicial Service Commission, JSC, which plays a key role in judicial appointments and security of tenure, particularly after apartheid. Judicial appointments. The JSC, consisting of lawyers, judges, and politicians, is responsible for appointing Superior Court judges, although the President's role is only advisory for the Chief Justice, Deputy Chief Justice, and SCA leadership. Criteria for appointments focus on reflecting South Africa's racial and gender composition and ensuring impartiality. Judicial independence guarantees. Judicial independence is secured through oaths of office, security of tenure, financial security, and limited civil liability for judges. While lower courts and traditional courts are less independent, the superior courts protect their decisions and ensure impartiality. National Prosecuting Authority, NPA. The NPA is independent from both the government and the judiciary but plays a key role in the criminal justice system. The National Director of Public Prosecutions, NDPP, heads the NPA and is required to act independently. though the President appoints the NDPP, who must meet criteria set out in the NPA Act. Next. Page 7. Separation of powers and Chapter 9 institutions. 7.1 Introduction. Chapter 9 of the Constitution establishes institutions designed to support and strengthen constitutional democracy. These institutions include Public Protector, South African Human Rights Commission, Commission for the Promotion and Protection of the Rights of Cultural, Religious, and Linguistic Communities, Commission for Gender Equality, Auditor General, Electoral Commission. These institutions have two primary roles. 1. Checking the government, monitoring and ensuring accountability of government. 2. Contributing to the transformation of South Africa into a society with social justice. Independence. They are independent non-judicial institutions. They don't play the same role as the judiciary in enforcing the Constitution but are essential for ensuring that the government adheres to constitutional principles. Accountability. Though independent, these institutions are accountable to the National Assembly, NA. They can make findings and recommendations, and in the case of the Public Protector, issue binding remedial action. Separation of powers debate. While these institutions are independent from the legislature, executive, and other state organs, they are accountable to the National Assembly. This creates a complex relationship within the traditional separation of powers model. Some argue that Chapter 9 institutions form a fourth branch of government, each with its own unique relationship to other branches, similar to the National Prosecuting Authority. Role in democracy. These institutions play a crucial role in post-apartheid democratic South Africa, ensuring the adherence to constitutional values and principles, especially in a context of historical discrimination and oppression. Need for independence. For these institutions to fulfill their essential role, it is crucial that they have a degree of independence from other branches of government. Next. Page 7.2 Independence of Chapter 9 institutions. Essential independence. Chapter 9 institutions must maintain a level of independence from both the legislative and executive branches to effectively safeguard democracy and rights. However, they are non-judicial and don't enjoy the same institutional independence as the judiciary. Challenges faced. These institutions act as watchdogs to prevent abuse of power, especially by state entities, but also require cooperation from the executive and legislature to function. For instance, the Public Protector faces lack of cooperation from those she investigates, and the Auditor General had to cease operations due to death threats. Chapter 9 institutions, therefore, must balance independence with the need for collaboration from other branches of government. Constitutional guarantees. Section 181(2) guarantees the independence of these institutions, requiring them to act impartially, and exercise their powers without fear, favor, or prejudice. Section 181(3) obligates other organs of state to assist and protect the independence of these institutions. Section 181(4) prohibits any interference from persons or organs of state with the functioning of these institutions. Legislative support. Legislation provides additional protections. The Public Protector Act prohibits insulting the Public Protector or obstructing investigations, equating interference with contempt of court, punishable as a criminal offense. The Public Audit Act similarly protects the Auditor General from interference and prohibits misleading or obstructing the office, appointment and removal process. The Constitution establishes criteria for the appointment of key figures, for example, Public Protector, Auditor General, to ensure competence and integrity. These requirements include citizenship and being fit and proper. Specialized knowledge, for example, in auditing for the Auditor General. Reflection of race and gender composition in appointments to Chapter 9 commissions. Role of National Assembly. The National Assembly nominates and approves appointments. For the Public Protector and Auditor General, approval requires a 60% majority of the Assembly members. Other appointments need 50% approval. The selection process involves civil society participation, ensuring that candidates have broad political respect. Criticism of the appointment process. Critics argue that the process is flawed. Political party interests may influence the selection, compromising the independence of the candidates. Interviews alone may be insufficient to assess important personal qualities like integrity and reliability, which are critical for ensuring independence. Next. Page. Key points. Competency-based selection. Bazana suggests a more competency-based selection process for Chapter 9 institutions to ensure that apolitical, Professional individuals hold key positions. Job analysis is emphasized as a technical process, focusing on the duties and requirements of the job, along with the relative importance of each. Political influence and selection. The Constitution allocates the task of selecting candidates to the National Assembly, NA, introducing inevitable political considerations in the process. For the Public Protector and Auditor General, 60% support from the NA is required, potentially reducing party political influence when no single party holds a majority in the NA. Electoral Commission appointment. A separate procedure is followed for the Electoral Commission to reduce party political influence. A panel, consisting of representatives from various bodies, for example, Chief Justice, Human Rights Commission, nominates 8 candidates, from which the NA committee selects 5. The President then appoints the 5 candidates chosen by the committee, after they are approved by the NA. Removal of Chapter 9 officials. The Constitution protects officials from political removals. They can only be removed for misconduct, incapacity, or incompetence. Economic freedom fighters and others v. Speaker of the National Assembly and another established that removal is constitutional only if one of the listed grounds for removal is met. A preliminary inquiry is required to determine if grounds exist, and if found, the National Assembly decides whether to remove the official. Removal requires a 2/3 majority for the Public Protector or Auditor General, while a simple majority suffices for commissioners. The President must act on the NA's resolution for removal. Constitutional Court guidance. In Independent Electoral Commission v. Langburg Municipality, the Constitutional Court affirmed that Chapter 9 institutions are independent from the government, even though they are organs of state. These institutions perform functions under national legislation but are not subject to executive control, reinforcing the importance of institutional independence. The court emphasized the need for Chapter 9 institutions to be seen as outside government to ensure their independence. Next page. Key points. Langburg case. A clear distinction must be drawn between Chapter 9 institutions and the executive. Any action by the executive creating an impression that these institutions are not outside government is unconstitutional. Financial independence is crucial for these institutions to function effectively and without external influence, though Parliament provides the budget, not the institutions themselves. Financial independence. In the New National Party v. Government of the Republic of South Africa case, the Constitutional Court clarified that Chapter 9 institutions must have access to funds reasonably required for their duties. Parliament is responsible for providing these funds, considering national interests. The institutions must be able to defend their budgetary requirements before Parliament or relevant committees. The executive cannot stop the transfer of money without safeguards that ensure the institution's independence. Administrative independence. The administrative independence of Chapter 9 institutions is essential for their impartial functioning. These institutions must have control over their core functions, including staff management and program implementation. The executive is prohibited from interfering in day-to-day operations but is responsible for assisting when significant institutional issues hinder the institution's constitutional tasks. Parliament and the executive must engage constructively with these institutions to resolve problems but cannot remove control over their administration. Non-interference in day-to-day running. The Constitutional Court ruled that executive interference, for example, Department of Home Affairs directing the Electoral Commission, is not permitted. While institutions can request government assistance, the executive cannot control how they run their operations or manage personnel. Accountability to Parliament. Section 181(5) of the Constitution mandates that Chapter 9 institutions report to the National Assembly at least once a year, ensuring accountability. However, accountability does not mean subservience to Parliament. Institutions should report on their activities and performance while retaining independence in their day-to-day functions. The provisions of Section 181 strike a balance between independence and accountability, ensuring the institutions remain responsive and accountable without compromising their independence. Next page. Key points. Role and importance of the Public Protector. The Public Protector plays a decisive role in South Africa's democracy, often more influential than other Chapter 9 institutions due to its extensive powers to investigate maladministration and corruption. The Public Protector has been at the center of controversies, including debates over whether its remedial action is binding and frequent investigations of high-ranking government officials, including the President. Constitutional Court confirmed the Public Protector's role in promoting good governance and protecting citizens from impropriety and corruption. Court support for the Public Protector. The Constitutional Court in the Economic Freedom Fighters v. Speaker of the National Assembly case emphasized that the public protector is pivotal for good governance, especially in handling complaints against powerful government figures. Chief Justice Mogoeng described the public protector as a David fighting the Goliath of corruption and abuse of power in government. Powers and functions. The public protector's role is similar to an ombudsman but with broader powers, including investigating complaints about impropriety or prejudice in state affairs or public administration, reporting on improper conduct, taking remedial action. The Public Protector Act grants the public protector additional powers, such as investigating on their own initiative without waiting for complaints. The Supreme Court of Appeal confirmed the proactive nature of the public protector's work, meaning it can investigate on information from any source without needing a formal complaint. Investigation approach. The public protector is not passive in investigations and is required to act proactively when appropriate. The scope of investigations should not be limited, ensuring that they address the core issues. In Democratic Alliance v. Public Protector, the High Court emphasized that the public protector must conduct investigations thoroughly and ensure that remedial action is effective and credible. Next page. Key points. Powers of the public protector. The public protector can investigate maladministration at any level of government, including state-owned enterprises like Eskom, SABC, and PRASA. The public protector can also probe abuse of power, unfair conduct, or undue delays by public officials or those performing public functions that result in improper prejudice to others. The Act extends the public protector's powers to include investigating corruption under the Prevention and Combating of Corrupt Activities Act and improper enrichment related to government affairs. While the public protector investigates, it may refer matters to the Hawks, South African Police Service, or the National Prosecuting Authority, NPA, for further investigation and prosecution. The public protector itself cannot prosecute. Executive Members Ethics Act. The Executive Members Ethics Act grants the public protector the authority to investigate breaches of the Executive Members Ethics Code. The code applies to the President, cabinet members, premiers, and their executive councils, regulating conflicts of interest and misleading conduct. Judicial Review and Constitutional Court ruling. The Constitutional Court confirmed that the public protector has wide powers that ensure no government action escapes scrutiny. The public protector must be free to investigate without interference, and where all requirements for her powers are met, she must take appropriate remedial action to ensure good governance. The public protector must have adequate resources and capacity to execute her mandate effectively. Limitations on the public protector's powers. The public protector cannot investigate private companies unless there is an issue involving public funds. Complaints must generally be reported within 2 years of the occurrence, unless special circumstances exist. The public protector cannot investigate judicial functions performed by courts. Challenges to the public protector's findings. The public protector's findings and remedial actions are often resisted, especially by powerful office bearers. In a high-profile case involving former President Jacob Zuma, the public protector ordered that he repay the state for non-security-related expenses in the renovations at his Nkandla home. The president refused to comply, leading to a Constitutional Court ruling that the remedial action was binding. Constitutional Court on the binding nature of remedial action. The Constitutional Court ruled that remedial actions by the public protector are binding, particularly when it involves cases of unethical or corrupt conduct. Next page. Key points. Constitutional Court's rationale for binding remedial action. Binding nature. The Constitutional Court ruled that remedial actions taken by the public protector must often be binding to ensure effectiveness and contribute to strengthening constitutional democracy. Purpose. The public protector aims to uproot prejudice, impropriety, abuse of power, and corruption in government and state-controlled institutions. If remedial action is optional, it would have little impact, making the office ineffective. Constitutional source. The power of the public protector to impose remedial action is grounded in the Constitution, not the Public Protector Act. The Constitutional Court interpreted the relevant constitutional provisions to allow the public protector to impose appropriate and effective remedies. Binding versus non-binding. Whether remedial action is binding depends on the nature of the issue, findings made, and the remedy taken. Recommendations may not be binding, but instructions are likely binding. Legal consequences. When remedial action is binding, compliance is mandatory, and failure to comply has legal consequences. Challenge and review of public protector's findings. Inquiry into findings. Individuals affected by the findings can still inquire into the correctness of the report. However, non-compliance with binding action cannot be justified by an inquiry or parallel process, for example, internal investigations contradicting the public protector. Court review. Affected parties may challenge the findings and remedial actions in court. Until a court sets aside the findings, the action must be complied with. Nakandla case. The former President Zuma did not challenge the public protector's report through judicial means and therefore was required to comply with the remedial action regarding the Nakandla renovations. Criticism and praise of the Constitutional Court's judgment. Praise. The ruling has been widely praised for ensuring the binding effect of the public protector's remedial action. Criticism. Woolman's argument. Criticism centers on the court's sweeping ruling about the binding nature of remedial actions. Some argue that the court could have addressed the matter case by case rather than creating a general theory. Concerns about non-compliance. The judgment arose due to persistent non-compliance with the public protector's recommendations, particularly by the president and ministers. This non-compliance would likely have required the public protector to seek court enforcement, which could be costly. Conceptual concerns. Woolman raised concerns that the public protector might act beyond its investigatory and problem-solving role and become a detector, prosecutor, judge, and jury, which could lead to abuses of power. However, the reviewability of the public protector's decisions by the courts mitigates this risk. Checks and safeguards. The courts provide a check on the power of the public protector. If there are concerns about abuse of power or overreach, the courts can review and set aside the findings or remedial actions, as has occurred in some cases. Next page. Key points. Public Protector v South African Reserve Bank. The Constitutional Court ruled that the public protector's conduct was extraordinary and unlawful in ordering Parliament to amend the Constitution. The court confirmed the High Court's order that the public protector pay a percentage of costs on a punitive scale due to her misconduct during the investigation, including falsehoods and misstatements. The misconduct included misrepresentation of evidence, failure to provide complete records, obfuscating reasons for non-disclosure of material meetings, failure to provide a candid account of her conduct. Review of public protector's findings and remedial action. Remedial action is not unfettered and is subject to judicial scrutiny. Affected individuals may challenge the findings and remedial action but cannot appeal the merits of the report. Legal ground for review. The public protector's actions must be in compliance with legality. The grounds for review include unlawfulness, vagueness, or irrationality. Minister of Home Affairs v. Public Protector. The Supreme Court of Appeal clarified that the public protector is not a state organ and its decisions are not administrative in nature, thus not subject to PAHA, Promotion of Administrative Justice Act. Review under legality. Challenges to the public protector's findings must be reviewed based on legality, whether it is lawful, rational, and within her constitutional mandate. Rationality and investigation. In Democratic Alliance v. Public Protector, the High Court emphasized that the public protector's findings and remedial actions must be rationally related to the purpose for which her powers were granted. This includes discovering and exposing corruption and prejudice, remedying instances of corruption and holding those responsible accountable. Doctrine of separation of powers. In South African Reserve Bank v. Public Protector, the public protector ordered Parliament to amend the Constitution, which was found to be an overreach, violating the separation of powers. Court's ruling. The public protector cannot impose remedial action that infringes on Parliament's exclusive authority to enact national legislation. Directing or prescribing constitutional amendments violates the principle of separation of powers. The public protector operates under the Constitution and cannot overstep by instructing the legislature or other branches of government. Remedial action and separation of powers. The public protector cannot order actions like the removal of a cabinet member by the president, as this would infringe upon the executive's constitutional powers and violate the separation of powers. Scope of public protector's powers. The public protector has broad powers to investigate maladministration and corruption but must exercise those powers within the constitutional and statutory mandate. The courts may play a role in holding the public protector accountable by reviewing the legality of her findings, but cannot intervene based on the correctness of the findings. The public protector's findings are often binding, but they cannot be overturned merely because they are flawed, unlike judicial decisions that are subject to appeals. Conclusion. The public protector has extensive investigative powers and can impose remedial action. However, such action must comply with constitutional principles, including legality and rationality, and cannot infringe on the separation of powers. Judicial review of the public protector's findings is limited, focusing on whether the action was lawful, rational, and within the mandate, rather than on the merits of the findings. Next page. Summary of Chapter 9 Institutions. Chapter 9 Institutions. The Constitution establishes several Chapter 9 institutions to promote and safeguard democracy, including Human Rights Commission, Public Protector, Auditor General, Electoral Commission, Independence and Accountability. These institutions are independent, with their independence constitutionally guaranteed and reinforced by legislation. They are required to report on their activities and the performance of their functions to the National Assembly, NA, at least once a year and account to the NA. Judicial comparison. The Constitutional Court confirmed that these institutions are not part of the government and enjoy both institutional and administrative independence. Unlike the judiciary, these institutions do not make binding findings enforceable in the same manner as the courts. They primarily help hold government officials accountable and typically make recommendations for remedial action rather than issuing binding decisions. Next page. 8.1 The division of powers between spheres of government, general principles. 8.1.1 Introduction. Constitutional power division. The Constitution divides power both vertically, across branches of government, legislative, executive, and judiciary, and horizontally, across national, provincial, and local spheres of government, establishing a quasi-federal system. Section 41. Government is constituted of national, provincial, and local spheres that are distinctive, interdependent, and interrelated. 8.1.2 Historical background. South Africa's division of powers has evolved from a hierarchical model to one where all spheres have equal constitutional status, moving away from the concept of a level of government to the term sphere. 8.1.3 The constitutional principles. Each sphere has geographic, functional, and institutional integrity and is allocated powers directly by the Constitution. Interference between spheres is generally not permitted unless authorized by the Constitution or legislation. 8.1.4 The principles of cooperative government. The spheres of government must work together in a cooperative manner to ensure that democratic governance and service delivery are achieved. 8.1.5 Cooperative government and coordination of intergovernmental relations. Cooperative government requires coordination and mechanisms to resolve disputes or conflicts between the spheres of government. 8.2 Division of legislative and executive power between national and provincial spheres. Legislative competence. Powers of national and provincial governments must be balanced to avoid conflicts. Pith and substance test, a principle used to determine the appropriate division of legislative powers. 8.2.4 Conflicts between national and provincial spheres. Concurrent competences, addressing conflicts in areas where both national and provincial governments have authority, outlined in Schedule 4. Exclusive provincial competences, resolving conflicts related to areas exclusively under provincial jurisdiction, outlined in Schedule 5. 8.2.5 National intervention in provincial administration. National government may intervene if provincial administration fails to function correctly. 8.3 Division of legislative and executive power between national, provincial, and local spheres. Local government objectives and structure. Local government plays a crucial role in service delivery and governance. Municipal powers. Original powers granted by the Constitution. Assign powers from other spheres. Incidental powers. 8.3.5 Conflicting national, provincial, and municipal laws. Conflicts between laws at different spheres must be resolved to ensure effective governance. 8.3.6 Supervision of local government. Oversight is required to ensure local government adheres to constitutional mandates. 8.4 Financial affairs. Fiscal powers, division of fiscal responsibilities and revenue collection. Revenue distribution, the process of distributing government funds among national, provincial, and local spheres. 8.4.6 The central bank. Role of the central bank in managing financial stability. 8.4.7 Procurement. Preferential Procurement Policy Framework Act 5 of 2000, regulates the procurement process to ensure fairness and equity. Conclusion. South Africa operates a quasi-federal system, where national power is dominant but provinces and local municipalities also play significant roles in governance. This system promotes democracy and service delivery while maintaining constitutional integrity across all spheres of government. Next page. 8.1.2 Historical background. Pre-colonial government structure. Before colonial occupation, traditional African governance was divided into three tiers. Chief, responsible for central government. Headman, oversaw the ward. Family head, led at the family level. Colonial impact. The Dutch and British introduced settler governments, making the central government of settlers the primary source of power over African leaders. The apartheid government systemically fragmented South Africa into self-governing and independent ethnic or tribal entities, homelands. The goal of Grand Apartheid was to strip black South Africans of their citizenship and grant them citizenship in these homelands, where they could exercise their rights. Post-apartheid transition. During negotiations for South Africa's interim constitution, the African National Congress, ANC and liberation organizations were initially opposed to a federal system, fearing it would resemble the apartheid-era homeland system. The ANC later recognized the potential benefits of strong regional government for service delivery and political empowerment, especially after exposure to integrated federalism models, for example, German Constitution. Inkatha Freedom Party, IFP, advocated for a strong federal system with asymmetrical power for KwaZulu-Natal, KZN. The inability to reach consensus led to the IFP's boycott of the constitutional drafting process, but they later participated in the 1994 democratic elections, contributing to ending civil strife in KZN. 8.1.3 The Constitutional Principles. Constitutional transition. South Africa's transition to democracy involved a two-stage process, with the final constitution having to align with 34 constitutional principles from the multi-party negotiations. Key constitutional principles. Structure of government. Government must be structured at national, provincial, and local spheres. The powers and functions of these spheres should be defined in the final constitution and should not be substantially inferior to those in the interim constitution. Legislative powers. The national and provincial spheres must have exclusive and concurrent powers. Powers allocated to either sphere should follow listed criteria. National government should not encroach on the geographical, functional, and institutional integrity of provinces. Dispute resolution. Disputes between the national and provincial spheres over legislative powers must be resolved by a court. Local government. A framework for local government powers, functions, and structures must also be included in the Constitution. Equitable share of revenue. Each sphere must receive an equitable share of national revenue to ensure it can provide basic services and execute its functions. Constitutional Court's role. In ex parte chairperson of the Constitutional Assembly, the Constitutional Court found the diminution of provincial power to be inconsistent with Constitutional Principle 18. This required adjustments in the allocation of powers to provinces and the override clause allowing national legislation to prevail over provincial legislation. Certification of the amended text, the revised override clause, Section 146, and a reallocation of powers to provinces met the court's approval, aligning with Constitutional Principle 18. Next page. 8.1.4 The Principles of Cooperative Government. Integrated Federalism. South Africa follows an integrated federalism model, meaning that the division of power between national, provincial, and local governments must be managed through mechanisms like cooperative government. Shared legislative power. Provincial and local governments share lawmaking powers with the national government over key areas like education, environment, health, and policing. Schedule 4 of the Constitution. Part A of Schedule 4. National and provincial governments have shared powers. Part B of Schedule 4. National, provincial, and local governments share powers. Concurrent powers. National and provincial governments have equal lawmaking power over matters listed in Part A of Schedule 4. Their lawmaking power over matters in Part B of Schedule 4 is limited and does not extend to administration. Conflict resolution. When national and provincial laws conflict, national law will override provincial law, but only if it meets the criteria in Section 146 of the Constitution. If national or provincial legislation is inoperative due to a conflict, a bylaw may be considered valid if it's not in conflict with any act of national or provincial law. Exclusive powers. Provincial and local governments have exclusive power to legislate over regional or local matters as per Schedule 5. National government can intervene in these exclusive matters if necessary to achieve constitutional objectives. Section 44(2). National government's authority. National government has the authority to legislate and administer laws on subjects not mentioned in Schedules 4 or 5, effectively granting it plenary powers. 8.1.5 Cooperative government and the coordination of intergovernmental relations. Overlap of powers. South Africa's constitutional framework requires coordination mechanisms to manage potential conflicts between the national, provincial, and local spheres of government. Cooperative government. Chapter 3 of the Constitution emphasizes the principles of cooperative government, including the interdependence and mutual respect between the different spheres of government. Section 41 mandates that all spheres of government respect the constitutional status and powers of other spheres, exercise powers without encroaching on other spheres' functions, cooperate in good faith and mutual trust. Intergovernmental disputes. Organs of state must try to resolve disputes through political mechanisms before resorting to the courts. Legal action should only be taken after exhausting other remedies. The Constitutional Court's ruling in Utukela District Municipality v. President of South Africa emphasized that disputes should be resolved politically and not through litigation unless all avenues have been exhausted. Coordinating bodies. The Intergovernmental Relations Framework Act, IGRFA, establishes forums for coordinating the activities of the different spheres of government, including the President's Coordinating Council, National and Provincial Intergovernmental Forums, District Intergovernmental Forums. These bodies aim to foster coherent government, ensure effective service delivery, and monitor policy implementation. Coercive versus cooperative intergovernmental relations. Some scholars, like Stiegler, distinguish between cooperative and coercive intergovernmental relations, arguing that while the Constitution encourages cooperation, the IGRFA tends to create a more coercive system, with the national government exerting significant control over the other spheres. Next. Page 8.1.6 The intended role of the principle of subsidiarity. Purpose of the principle ensures that powers are delegated to the lowest sphere of government first, as they are closest to the people and understand their needs best. Application. Higher spheres of government, national/provincial, can only intervene in the local sphere if local government is unable to deliver services or perform its functions. Balance. The principle emphasizes local government autonomy while maintaining support from higher levels, addressing issues like service delivery and public unrest. Implementation protocols, IGRFA. When organs of state work together to deliver services, they must agree on implementation protocols that define roles and responsibilities, set aims, objectives, and measurable indicators, include mechanisms for monitoring, evaluation, and dispute resolution. Outline the duration of the protocol. Intergovernmental disputes. Disputes can arise when different government spheres or organs of state disagree over statutory functions or agreements. Disputes must be justiciable and involve matters of statutory powers/functions. Excluded. Disputes involving interventions under Sections 100 and 139 of the Constitution. Duty to avoid and settle disputes. The IGRFA imposes a duty on organs of state to avoid and resolve disputes without resorting to legal proceedings. Principles of public administration. Resolving disputes amicably is essential to ensuring efficient, economic, and effective governance, avoiding resource-draining litigation. Steps to resolve disputes. 1. Initial step. Attempt resolution through direct negotiations or an intermediary. 2. Formal dispute. If negotiations fail, one party can formally declare an intergovernmental dispute in writing. 3. Dispute resolution meeting. Once declared, a meeting must be convened to identify disputed and non-disputed issues, explore mechanisms, non-judicial, to settle the dispute. Appoint a facilitator for the dispute. 4. Failure to convene. If the meeting is not convened and involves a national organ, the Minister for Local and Provincial Government must intervene. 5. Facilitator's role. The facilitator helps resolve the dispute and provides progress reports, which are privileged and not admissible in court. Judicial proceedings. Judicial proceedings can only occur once the dispute has been formally declared and all efforts to settle it have failed. Courts will not entertain a dispute unless all prescribed steps have been followed. Next. Page 8.2 The division of legislative and executive power between the national and provincial spheres of governments. 8.2.1 Introduction. Multi-sphere government. The Constitution creates a system where legislative and executive powers are divided between the national and provincial spheres. Overlap. There is significant overlap between the powers of each sphere, but provincial executives may have additional administrative powers delegated by the national legislature. Provincial authority. Provincial executives largely have authority over the same matters as provincial legislatures, with some delegation for administrative functions. 8.2.2 The objectives and structure of provincial government. Provinces. South Africa has 9 provinces, and each is governed as per Chapter 6 of the Constitution. Key functions of provinces. 1. Link between voters and government. Provinces help address unique needs and challenges in specific geographical areas. 2. Implement national policies. Provinces are responsible for executing national policies in service delivery areas like housing, healthcare, policing, and education. 3. Oversee local government. Provinces supervise local governments within their jurisdiction. 8.2.3 Debate on provincial government and democracy. Criticism. The provincial sphere of government has faced criticism for inefficiency, with calls for reducing the number of provinces from 9 to 6. This was supported by the ANC in 2007 and again in 2017, with discussions around reconfiguration. Counter-argument, Stephen Friedman. Provincial government enhances democracy by allowing for better accountability and responsiveness to local needs. Example, in Northwest Province, voters rejected a non-performing premier and his allies, demonstrating that provincial governments provide voters with more options for expressing preferences. Local government supervision. Provinces play a critical role in overseeing local governments, ensuring effective service delivery amidst dysfunctionality at the local level. 8.2.4 Structure and functions of provinces. Provincial constitutions. Provinces may pass their own constitution, but it cannot conflict with the national constitution. The national constitution sets the fundamental structure of governance, and provincial constitutions cannot alter the province's role or their relationship with other spheres of government. Legislative authority of provinces. Provincial legislatures have the power to 1. Pass provincial legislation on matters in Schedule 4 and Schedule 5. 2. Legislate on matters explicitly assigned to the province by national legislation. 3. Enact laws for matters requiring provincial legislation as envisaged by the Constitution. Provincial legislatures may assign legislative powers to municipal councils within the province. Provincial legislatures can request Parliament to change the name of a province with a 2/3 majority vote. Legislation necessary for the exercise of powers in Schedule 4 is considered as legislation on matters in Schedule 4. Membership of provincial legislatures. Provincial legislature members are elected using the same system as for the National Assembly. Each legislature's size is determined based on the province's population but must have between 30 and 80 members. Western Cape, the size of its legislature is determined by its provincial constitution. Term and dissolution. Provincial legislatures serve a 5-year term, and can be dissolved earlier under the same conditions as the National Assembly. Next page. Division of legislative and executive power. Continued 8.2.5 Role of permanent delegates to the NCOP. NCOP membership. Permanent delegates to the National Council of Provinces, NCOP, are not members of the provincial legislature. Attendance and speaking. While delegates may attend and speak in their provincial legislature and its committees, they cannot vote. Requirement to attend. The provincial legislature can require permanent delegates to attend its sessions or committees. 8.2.6 Executive authority of provincial government. Premier's role. The Premier holds executive authority in the province, similar to the President at the national level. Differences. Unlike the President, the Premier does not have the head of state powers outlined in Section 84 of the Constitution. Specific powers of the Premier. Section 127(2). Assent to and signing bills. The Premier must sign bills passed by the provincial legislature. Refer bills. The Premier can refer a bill back to the provincial legislature or to the Constitutional Court for a decision on its constitutionality. Summon legislature. The Premier can summon the provincial legislature for special sessions. Appoint commissions of inquiry. The Premier can appoint commissions for investigations. Call referendums. The Premier can call referendums in accordance with national legislation. Functions of the Premier with the Executive Council. Implement provincial and national legislation. Ensures provincial legislation is enacted and enforces national legislation in Schedules 4 and 5, unless the Constitution or national legislation stipulates otherwise. Develop and implement provincial policy. The Premier helps to create and carry out provincial policies. Coordinate provincial administration. Ensures coordination across the provincial government and its departments. Initiate provincial legislation. The Premier plays a key role in preparing and initiating legislation at the provincial level. Other functions. Performs any other duties assigned by the Constitution or an Act of Parliament. 8.2.7 Administrative capacity and disputes. Executive authority and administrative capacity. Provinces have executive authority within the functional areas listed in Schedules 4 and 5, but only to the extent they have the administrative capacity to manage those responsibilities effectively. National government's role. The national government is responsible for assisting provinces in developing the necessary administrative capacity for the effective exercise of their powers and functions. Disputes over administrative capacity. If a province lacks administrative capacity for a function, the matter must be referred to the NCOP for resolution within 30 days. 8.2.8 Assignment of powers to municipalities. Delegation of functions. A member of the Provincial Executive Council can assign any of their powers to a municipal council. Conditions. The assignment must be made through an agreement between the relevant Executive Council member and the municipal council. The assignment must comply with the relevant national or provincial legislation. The assignment becomes effective upon the Premier's proclamation. 8.2.9 Election and removal of the Premier. Election. Premiers are elected by the provincial legislature. Removal of premiers. 1. Impeachment. A premier can be impeached under Section 133 for serious constitutional violations, misconduct, or inability to perform office duties. 2. Motion of no confidence. A premier can be removed by a motion of no confidence in the provincial legislature as per Section 141 of the Constitution, which can be based on political reasons. Next page. Premier, Limpopo Province v. Speaker of the Limpopo Provincial Legislature and others. Facts of the case. In 2009, the Limpopo Provincial Legislature passed the Financial Management of the Limpopo Provincial Legislature Bill, 2009, aimed at regulating the financial management of the Limpopo Provincial Legislature. The Premier of Limpopo refused to assent to the bill, citing concerns about its constitutional validity. The Premier argued that the financial management of the provincial legislature was not listed as a functional area in Schedules 4 or 5 of the Constitution, and therefore the bill fell outside the provincial legislature's legislative competence. The provincial legislature argued that the bill fell within its competence because it had been expressly assigned by the Financial Management of Parliament Act and was envisaged by Sections 195, 215, and 216 of the Constitution. The Constitutional Court ultimately ruled that the bill was unconstitutional and invalid, as the provincial legislature did not have the authority to pass such legislation. Key points. Limited legislative powers of provinces. Provincial legislatures have limited legislative powers compared to Parliament. The powers of the provincial legislatures are confined to those matters listed in Schedules 4 and 5, matters expressly assigned to them by national legislation, or matters envisaged by the Constitution. Court's majority opinion. Enumerated powers. The majority of the Constitutional Court emphasized that provincial legislative powers are clearly defined and enumerated in the Constitution, and that any additional powers must be explicitly assigned or envisaged in the Constitution. Assignment of powers. The Financial Management of Parliament Act did not clearly and unequivocally assign the power to legislate on financial management of the provincial legislature to the provinces. Clarity of assignment. The court required that any power assigned to the provinces must be clear and leave no doubt about the intent of the national legislation. Ambiguities could blur the boundaries of provincial powers and lead to uncertainty. Envisagement. The court held that Sections 195, 215, and 216 did not envisage provincial legislation regulating financial management. It required explicit provisions in the Constitution for provincial legislatures to pass such laws. Dissenting opinion. The minority disagreed with the restrictive interpretation of the word envisages. They argued that it must carry a different meaning from expressly assigned, indicating a broader understanding that allowed for provincial legislation. According to the minority, the Constitution did indeed envisage such powers, based on the context of Sections 195, 215, and 216, which they believed contemplated the power for provinces to regulate financial management within the provinces. Should the Premier have the power to refer constitutional matters to the Constitutional Court? Premier's role in the constitutional scheme. The Premier's ability to refer matters to the Constitutional Court is important in ensuring the constitutional validity of legislation passed by provincial legislatures. The Court's judgment helps define the scope of provincial legislative authority and ensures adherence to the Constitution. This mechanism serves as a safeguard to uphold constitutional principles and ensures that provinces do not overstep their legislative competences. However, the power to refer such matters should be exercised judiciously, as unnecessary litigation could lead to delays and increased legal costs. The referral should be based on reasonable constitutional concerns rather than purely political motivations. Conclusion. Majority's reasoning. I agree with the majority's reasoning in this case. The clarity and certainty in the division of legislative competences between the national and provincial spheres are fundamental principles of the Constitution. The majority decision upholds this clarity by strictly interpreting the legislative powers of provinces. It ensures that provinces cannot legislate in areas that are not explicitly assigned to them or envisaged by the Constitution, thus maintaining the integrity of the constitutional framework. Power to refer matters to the court. The Premier's power to refer constitutional matters is crucial to maintaining the rule of law and ensuring compliance with the Constitution. Given the complexity of the division of powers, it is essential that disputes regarding the scope of provincial legislative authority be resolved by the Constitutional Court. Therefore, the Premier should have such a power, but it should be used responsibly and only in cases of genuine constitutional concerns. Next. Page 8.2.3 Determining legislative competence, the pith and substance test. Context. Legislative powers of Parliament and provincial legislatures. There is an overlap between the legislative powers of Parliament and provincial legislatures, especially concerning concurrent competences in Schedule 4 and exclusive competences in Schedule 5 of the Constitution. Conflicts. Conflicts between national and provincial legislation on the same subject are regulated by Section 146 of the Constitution, with national legislation prevailing in certain circumstances. Federalist limits. The Constitution imposes limits on the legislative powers of each sphere of government, ensuring that no legislature enacts legislation outside its competence. Two key issues. 1. Determining whether the legislation falls within Schedule 4 or 5. The pith and substance test is applied to assess whether the legislation falls within the scope of Schedule 4 or 5. 2. Legislature's authority to pass legislation. Once the legislation is identified as falling within Schedule 4 or 5, the next step is to determine whether the legislature is authorized to pass it as a matter of course or in terms of Section 44(2). The pith and substance test. Definition. The test determines the true purpose or substance of the legislation. It seeks to identify the essence or primary goal of the bill, beyond incidental provisions that do not affect its core purpose. A bill may have multiple pith and substance purposes if it seeks to achieve more than one goal. Provisions that are incidental and do not pertain to the main purpose are excluded when determining legislative competence. Key case, ex-party President of the Republic of South Africa, in reconstitutionality of the Liquor Bill. Facts. Parliament passed the Liquor Bill to regulate the liquor industry. The bill divided the industry into manufacturing, distribution, and retail sales. Parliament sought national regulation of manufacturing and distribution, while retail sales was considered a provincial matter. The President referred the bill to the Constitutional Court to assess its constitutionality, questioning whether liquor licensing, a provincial matter under Schedule 5, was being encroached upon by national regulation. Court's analysis. The Constitutional Court acknowledged that Parliament regulates interprovincial matters, such as manufacturing and distribution, while provincial legislatures have exclusive authority over interprovincial matters, such as retail sales. The court applied the pith and substance test to determine whether the bill dealt with issues under Schedule 4 or Schedule 5. The pith and substance of the bill was primarily concerned with regulating the manufacture and distribution of liquor, which was an interprovincial issue falling under Schedule 4. The retail sale of liquor, on the other hand, fell within Schedule 5, granting provinces exclusive competence. Therefore, the court found the provisions regulating manufacturing and distribution to be constitutional, while those concerning retail sales violated provincial powers. Court's conclusion. Manufacturing and distribution. The national government has competence over interprovincial regulation, and the national legislation on these matters was constitutional. Retail sales. The regulation of retail liquor sales fell under the exclusive competence of provincial legislatures, and national regulation of this matter was unconstitutional unless justified under Section 44(2). Key principles. The pith and substance test focuses on the primary purpose of legislation to determine which level of government has the competence to legislate. Legislation that has dual purposes or incidental provisions must still be examined by its main substance to determine its constitutionality. Cooperative government. The Constitution promotes cooperation between spheres of government, requiring careful interpretation of legislative powers to avoid encroachment between levels. Conclusion. The pith and substance test is essential in clarifying whether national or provincial legislation governs a particular subject, especially in cases involving overlapping competences under Schedules 4 and 5. The liquor bill case exemplifies how the test is applied to ensure that the division of powers between national and provincial governments is respected and maintained, reflecting the constitutional commitment to federalism and cooperative government. Next page. The substantial measure test versus the pith and substance test for bills. Key difference. Pith and substance test, used to determine whether the subject matter of a bill falls within Schedule 4, concurrent competence, or Schedule 5, exclusive provincial competence. This test identifies the true purpose of the bill, considering what the legislation is primarily about. Provisions that fall outside this core purpose are treated as incidental. Substantial measure test, tagging test, used to decide whether a bill should be tagged as a Section 75 bill, not affecting provinces, or a Section 76 bill, affecting provinces. This test focuses on all provisions of the bill, assessing the extent to which they substantially affect functional areas listed in Schedule 4, rather than determining the core purpose or substance of the bill. Tagging versus competence. Tagging concerns how a bill should be processed in the legislative process and which spheres of government, national, provincial, should have a say in its passage. A bill that affects Schedule 4 areas, concurrent competences, should be tagged as a Section 76 bill. Tagging is not concerned with legislative competence but with the extent of provincial involvement in the legislative process. Pith and substance focuses on determining whether the substance of a bill falls within the competence of a particular sphere of government, national or provincial, based on Schedule 4 or Schedule 5. Key case, Tungon and others v. National Minister for Agriculture and Land Affairs. Constitutional Court's view. The court highlighted the distinction between the pith and substance test and the substantial measure test. The pith and substance test determines the true purpose of legislation and whether it falls within a specific legislative competence. The tagging test determines how to classify the bill based on the extent it affects provincial interests and concerns, not its true purpose. Additional case, Abalali Base Mjundalo Movement Essay and another v. Premier of the Province of KwaZulu-Natal. Issue. The court assessed whether the Elimination and Prevention of the Re-emergence of Slums Act, passed by the KZN provincial legislature, fell within the provincial legislature's competence, specifically whether it dealt with housing, Schedule 4 competence, or land tenure/access to land, Schedule 5 competence. Court's approach. Principles for determining substance. 1. The substance of the law is based on its true purpose, effect, and essence, not its form. 2. Legislative competences are not watertight, and determining the true substance of the legislation is essential to understanding whether the provincial legislature has competence. The court determined that the substance of the act was about housing, making it fall within Schedule 4, provincial competence. However, it struck down Section 16 of the Act, which required evictions that were inconsistent with the Prevention of Illegal Eviction from an Unlawful Occupation of Land Act, PI Act, as unconstitutional. Conclusion. Pith and substance test identifies the true purpose of a bill to determine if it falls within Schedule 4 or Schedule 5 legislative competences. Substantial measure test determines how to tag a bill based on how much it affects provincial concerns, not the substance of the legislation. Both tests help clarify the legislative competence of different spheres of government and ensure compliance with the constitutional division of powers. Next page. 8.2.4 The resolution of conflicts between the national and provincial spheres. 8.2.4.1 Conflicts related to concurrent competences, Schedule 4, concurrent legislative competence. Both Parliament and provincial legislatures can legislate over functional areas listed in Schedule 4, for example, education, which can lead to conflicting laws. Resolution framework. Section 146 of the Constitution addresses conflicts between national and provincial laws in concurrent competences. It involves a series of steps. 1. Legislative competence. Determine if both the national and provincial legislatures have the competence to pass the laws. 2. Reconciliation. If both legislatures have competence, attempt to reconcile conflicting laws. 3. Irreconcilable conflicts. If reconciliation is not possible, Section 146 decides which law prevails. Application of Section 146. If Section 146 criteria are met, national law prevails. If the criteria are not met, the provincial law prevails. Criteria for national law to prevail. Section 146(2). 1. Ineffective regulation. if the matter cannot be effectively regulated by provinces individually. 2. Uniformity requirement, if uniformity is necessary across the country, and national legislation provides it. 3. National interests, if national law is essential for security, economic unity, equal access to services, or environmental protection. Case law. Federation of Governing Bodies for South African Schools, FEDSAS, the court confirmed that provincial law is not automatically rendered inoperative by conflicting national law. Reconciliation is required before Section 146 is invoked. Example, if both national and provincial laws conflict over blue light brigades, Section 146 helps decide which law prevails. 8.2.4.2 Conflicts related to exclusive provincial competences, Schedule 5, Exclusive provincial competence. Provinces have exclusive legislative powers over matters listed in Schedule 5, for example, local government, liquor licensing. However, national parliament can intervene under certain circumstances. 1. National security, to maintain national security. 2. Economic unity, to maintain economic unity. 3. Essential national standards, to establish minimum standards for services. 4. Prevent unreasonable provincial actions, to prevent actions that harm other provinces or the country. Resolution of conflicts, Section 147(2). If national legislation intervenes and conflicts with provincial law in Schedule 5 matters, national law prevails under Section 147(2). Next. Page 8.2.5 National intervention in provincial administration. Context of intervention. National intervention occurs when a provincial government fails to fulfill its constitutional responsibilities. The national government can intervene to ensure the delivery of services, but the intervention must be subject to both substantive and procedural constraints to prevent abuse. Legal framework, Section 100. Purpose. Section 100 of the Constitution permits the national executive to intervene and take necessary remedial measures when a province is unable to fulfill its executive obligations. Types of intervention. 1. Intrusive, taking full responsibility for the province's obligations. 2. Less intrusive, deploying skilled personnel or providing support by consent. Substantive constraints, the intervention must serve one of the following objectives. 1. Maintain national standards, ensure essential national standards or minimum service standards are met. 2. Economic unity, to maintain national economic unity. 3. National security, to maintain national security. 4. Prevent harm to other provinces, to prevent the province from taking actions detrimental to the interests of other provinces or the country. If challenged, the national executive must demonstrate the intervention is necessary to achieve these objectives. Procedural constraints. Notification to NCOP. The national executive must notify the National Council of Provinces, NCOP, in writing within 14 days of the intervention. Time limit. The intervention must end within 180 days unless the NCOP expressly approves its continuation. Review and approval by NCOP. For the intervention to continue beyond 180 days, the NCOP must approve it after reviewing its necessity. The NCOP can reduce the intensity of the intervention if the province's capacity to deliver services improves. National legislation. The Constitution allows for the enactment of national legislation to regulate the process of national intervention in provincial administration. Next. Page 8.3 The division of legislative and executive power between the national, provincial, and local spheres of government. 8.3.1 Introduction. Division of power. The Constitution divides legislative and executive powers among the national, provincial, and local spheres of government. Focus. This section focuses on the division of power between the national/provincial spheres and the local sphere of government. 8.3.2 The objectives of local government. Section 152(1) outlines the objectives of local government. 1. Democratic and accountable local government. Ensure local government is responsive to the needs of local communities. 2. Sustainable service provision. Ensure services are provided in a sustainable manner. 3. Social and economic development. Promote social and economic development in the community. 4. Safe and healthy environment. Promote a safe and healthy environment for communities. 5. Community involvement. Encourage active involvement of communities and organizations in local government matters. Section 153 expands on the obligations of municipalities. 1. Priority to basic needs. Municipalities must prioritize the basic needs of the community in their administration and budgeting. 2. Promotion of development. Ensure social and economic development through planning and administration. 3. Participation in national/provincial programs. Engage in national and provincial development initiatives. Constitutional Court ruling, Joseph and others v. City of Johannesburg. Key objective. The court emphasized that the primary goal of local government is to meet the basic needs of all South African inhabitants. Mandatory establishment of municipalities. The establishment of wall-to-wall municipalities across South Africa is mandatory. Basic municipal services. Municipalities are obligated to provide basic services, like water and electricity, to all inhabitants, regardless of whether they have contracted for these services. This duty is in line with Sections 152 and 153, along with the Local Government, Municipal Systems Act. Next page. Street renaming and decolonization, City of Tshwane AfriForum. Background. Resolution to rename streets. In 2007, the Tshwane Metropolitan Municipal Council decided to rename 25 streets in Pretoria to honor Indigenous heroes and heroines, aligning with the Constitution's goals of national unity, reconciliation, and healing past divisions. Council's intentions. The renaming aimed to acknowledge and address the heritage of colonialism and apartheid. AfriForum's opposition. AfriForum challenged the process, claiming the council had not followed the correct procedure and that their cultural rights were infringed. Legal proceedings. Temporary delay. AfriForum and the council reached an agreement for a 6-month delay before implementing the name changes, allowing AfriForum time to seek judicial review. AfriForum did not file the review application. Interdict by AfriForum. AfriForum sought an urgent interdict to prevent the name changes, which the High Court initially granted. The Supreme Court of Appeal, SCA, dismissed the appeal, leading to an application to the Constitutional Court. Constitutional Court judgment. Majority judgment. Context. The court emphasized South Africa's deep wounds from colonialism and apartheid, with black South Africans historically deprived of a sense of place and belonging. Ubuntu philosophy. The council's decision was framed within the notion of Ubuntu, acknowledging that individuals only achieve completeness when others are respected and appreciated. Interim relief requirements. AfriForum had to demonstrate that its rights were prima facie, that harm was imminent, and that the balance of convenience favored them. Court's findings. No irreparable harm. AfriForum failed to prove irreparable harm, as any temporary damage could be remedied if the name changes were overturned. Balance of convenience. The majority found that Tshwane belongs to all people and that the harm to AfriForum was outweighed by the majority's sense of belonging from the name changes. Appeal grant. The court allowed the council's appeal, determining that AfriForum did not meet the criteria for an interdict. Minority judgment. Common law rules. The minority advocated for traditional common law rules regarding interim orders and felt the appeal should have been dismissed. Cultural rights. The minority disagreed with the majority's stance, arguing that cultural rights rooted in historical oppression should be protected. Public participation. The minority stressed the importance of ensuring proper public participation and adhering to the rule of law before implementing the changes. Key principles and court's rationale. Separation of powers. The court highlighted that the council has the constitutional and statutory authority to make policy decisions for the city, which must be respected by the judiciary. Flexibility in public participation. Public participation in the decision-making process does not equate to co-governance. The council had met the requirement for public consultation, even though AfriForum disagreed with the process. Ubuntu and constitutional values. The court emphasized Ubuntu and the importance of respecting diverse cultures, acknowledging that the renaming was a step toward reconciliation and healing past wounds. Next page. 8.3.3 The structure of local government. Categories of municipalities. Section 155 of the Constitution distinguishes 3 types of municipalities. 1. Category A, Metropolitan Municipality. Exclusive municipal executive and legislative authority in its area. Defined under Section 1 of the Local Government, Municipal Structures Act. 2. Category B, Local Municipality. Shares executive and legislative authority with a Category C municipality. Defined as a local municipality in Section 1 of the Municipal Structures Act. 3. Category C, District Municipality. Has authority over an area that includes more than one municipality, defined as a district municipality in Section 1 of the Municipal Structures Act. Establishment and criteria for municipalities. National legislation. Section 155 mandates that national legislation establish criteria for when an area should have a Category A municipality or both Category B and C municipalities. The Municipal Structures Act outlines these criteria. Metropolitan areas, defined as high-density areas with significant social and economic linkages. Section 1, Municipal Structures Act. Demarcation authority. The Municipal Demarcation Board has the power to determine and redetermine municipal boundaries, as per the Local Government, Municipal Demarcation Act. Independent authority for boundary determination. Section 155(3)(b) requires the Municipal Demarcation Board to determine municipal boundaries to avoid political interference. Constitutional Court ruling, Mototile Municipality v. President. Purpose of independent authority: to prevent political manipulation in the creation of new municipalities, ensuring a fair and multi-party democratic system. The court ruled that the process of determining boundaries must be entrusted to an independent body to preserve democracy. Municipal executive and participatory systems. The Municipal Structures Act provides for 3 executive systems and 2 participatory systems. 1. Executive systems. Collective executive system. Executive authority is vested in an executive committee. Mayoral executive system. Executive authority is vested in an executive mayor with a mayoral committee. Plenary executive system. Executive authority is vested in the municipal council. 2. Participatory systems. Subcouncil participatory system. Delegated powers exercised by subcouncils for parts of the municipality. Ward participatory system. Matters of local concern handled by committees at the ward level. Municipality-specific systems. Metropolitan municipality must have either a collective or mayoral executive system. May combine its executive system with subcouncil or ward participatory systems. Local municipality may have a collective, mayoral, or plenary executive system. May combine with a ward participatory system but not a subcouncil participatory system. District municipality may have any of the executive systems but cannot combine with subcouncil or ward participatory systems. Important considerations. 1. Institutional relationships. The structure of the municipality determines the relationship between its executive and legislative functions. 2. Ward committees. Only metropolitan or local municipalities may establish ward committees. 3. Subcouncils. Only metropolitan municipalities can establish subcouncils with delegated powers. Division of powers and functions. Constitution Section 155 provides for an appropriate division of powers between local and district municipalities, ensuring equitable and sustainable municipal service delivery. However, the division need not be symmetrical. The division must adhere to principles set out in the Local Government, Municipal Structures Act. Next. Page 8.3.4 Municipal Powers. General Overview. Executive and legislative authority. Municipalities derive their executive and legislative powers from the Constitution, specifically Section 156, which provides municipalities with authority over local government matters in Schedule 4 Part B and Schedule 5 Part B, along with matters assigned by national or provincial legislation. 2 types of powers. Original powers, directly derived from the Constitution. Assigned powers, assigned through national or provincial legislation. Additional powers. Section 156(5) allows municipalities to exercise powers necessary or incidental to performing their functions. Importance of democracy and cultural competence. Municipalities must uphold democratic principles. Appointment of officials on merit. Adherence to the rule of law. Accountability in democratic processes. Cultural competence is essential. Understanding cultural differences. Integrating cultural awareness and sensitivity into public service. Cultural competence supports municipalities' developmental duties, which aim to meet social, economic, and material needs and improve quality of life, as outlined in the White Paper on Local Government. 8.3.4.1 Original Municipal Powers. Section 156(1)(a). Municipalities have executive and legislative authority over matters listed in Schedule 4 Part B and Schedule 5 Part B of the Constitution. Section 156(5). Municipalities also have authority over matters necessary for or incidental to the effective performance of these functions. Constitutional protection. These powers can only be altered through constitutional amendments, making them foundational to municipal authority. Chapter 7 of the Constitution allocates specific powers to provinces and municipalities. Municipal Structures Act, 1998, regulates local government powers, often in relation to provincial jurisdiction. Some provisions were challenged by provinces, notably in the case Executive Council, Western Cape v. Minister of Provincial Affairs. Case Law, Executive Council, Western Cape v. Minister of Provincial Affairs. Issue: whether Parliament has concurrent powers over matters assigned to municipalities and provinces. Parliament's argument claimed legislative competence over all areas except those in Schedule 5, arguing that powers in Chapter 7 were concurrent. Constitutional Court ruling. Chapter 7 specifically allocates powers to municipalities and provinces. This allocation restricts Parliament's legislative competence over those powers. The court ruled that Parliament cannot legislate contrary to the constitutional allocation of powers, invalidating portions of the Municipal Structures Act that were inconsistent with Chapter 7. Next page. Bottom-up method for determining the scope of Schedule 4 and Schedule 5 matters. Constitutional Court interpretation. Case precedents. The Liquor Bill and City of Johannesburg Metropolitan Municipality v Gauteng Development Tribunal cases established that the scope and ambit of matters in Schedule 4 and Schedule 5 must align with the constitutional model of government. Power distribution between different spheres of government, national, provincial, and local, must guide the interpretation. Bottom-up interpretation. When two matters overlap, the more specific matter is defined first. The broader matter is only addressed if there are residual areas left. Gauteng Development Tribunal case. Key question: whether the power to approve land rezoning and township establishment falls under urban and rural development, broad matter in Schedule 4A, or municipal planning, specific matter in Schedule 4B. The Constitutional Court first defined the narrower, more specific scope of municipal planning before considering the broader matter of urban and rural development. The court concluded that municipal planning, including land rezoning and township establishment, falls under Schedule 4B, not urban and rural development. The court also emphasized that urban and rural development could not encompass municipal planning because this would infringe on the principle of cooperative government. Each sphere must respect the powers and functions of others without encroachment. Constitutional restrictions on national and provincial powers. Municipal powers. The Constitution grants municipalities the authority to legislate on matters in Schedule 4B and Schedule 5B. National and provincial governments have legislative powers over these areas but are limited by Sections 155(6)(a) and 155(7). Section 155(6)(a). Provincial governments must support and monitor local governments within their jurisdictions. Section 155(7). Both national and provincial governments can regulate municipal powers but cannot assume them. They can only regulate the exercise of executive municipal powers, not administer them. Court cases on the respect of constitutional functions. 1. City of Johannesburg Metropolitan Municipality v Gauteng Development Tribunal. The Constitutional Court ruled that national and provincial governments cannot usurp local government functions, especially municipal planning. National and provincial spheres may regulate municipal planning but cannot administer it. 2. Minister of Local Government, Western Cape v Lagoon Bay Lifestyle Estate, Proprietary, Limited. The court reinforced that national and provincial governments cannot take over local government functions unless there are exceptional circumstances. The court confirmed that urban and rural development cannot be broadly interpreted to include municipal planning. 3. Minister of Local Government, Environmental Affairs, and Development Planning, Western Cape v the Habitat Council and others, and Minister of Local Government, Environmental Affairs, and Development Planning, Western Cape v City of Cape Town. The court emphasized that municipalities are best suited to make decisions on land use, zoning and subdivision, since they have the most local knowledge and are closest to the citizens' needs. Provincial intervention in municipal land use decisions was held to be unconstitutional. 4. Tronox KZN Sands, Proprietary, Limited v KwaZulu-Natal Planning and Development Appeal Tribunal. The court declared Section 45 of the KwaZulu-Natal Planning and Development Act unconstitutional because it gave the provincial government authority over municipal planning decisions. Cooperative government principles prohibit provincial interference in matters exclusively under municipal jurisdiction. 5. ShopRite Checkers, Proprietary, Limited B. Premier, Gauteng Province. The court confirmed that municipalities have exclusive executive authority to approve height limitation relaxations for buildings within their areas, affirming municipal autonomy in land use matters. Summary of Constitutional Court's approach. Municipalities are granted exclusive authority over matters like land use and planning, Schedule 4B and Schedule 5B. National and provincial governments may regulate these powers but cannot usurp the functions of municipalities. The bottom-up method of interpretation ensures that specific powers are clearly defined first, preventing overlap and respecting the integrity of each sphere's authority. Cooperative government principles prohibit one sphere from encroaching on the powers of another, ensuring that municipal functions remain intact. Next page. 8.3.4.2 Assign municipal powers. Constitutional provisions for assigning powers. Section 44(1)(a), 3, and Section 104(1)(c). Both national and provincial governments can assign legislative powers to municipalities. This allows them to increase the legislative scope of specific municipalities or municipalities in general. Section 99 and Section 126. These sections allow national or provincial ministers to assign executive powers to specific municipalities. However, assignments must align with the act under which the power is exercised. These assignments are discretionary. Section 156(4). This section provides a mandatory framework for assigning the administration of matters in Parte of Schedule 4 or Parte of Schedule 5 to municipalities, provided specific conditions are met. Matter relates to local government. It would be most effectively administered locally. The municipality has the capacity to manage the matter. The municipal council agrees to the assignment. Section 156(4) aligns with the subsidiarity principle, which prioritizes the exercise of power as close as possible to the citizens. Clarification of legislative and executive power assignment. Relationship between Sections 156(4) and other provisions. Section 156(4) could be viewed as an additional basis for assigning both legislative and executive powers to municipalities. Or, it could be seen as defining the compulsory assignment of executive powers under Sections 99 and 126, contingent on agreement. Stiefler and Devisser's interpretation, the terms administration, agreement, and specific municipality suggest that Section 156(4) is not an independent basis for assignments but a principle for when executive power assignments under Sections 99 and 126 must be made. Assignment process. The assigning agent, either national or provincial, can set the parameters for the assigned power. The assignment is meant to be complete, transferring the final decision-making authority in matters related to the function. Section 151(4) of the Constitution requires compliance with the principles for the assignment of functions to municipalities. The Local Government, Municipal Systems Act governs how these powers and functions are transferred, whether by legislation, executive act, or agreement. 8.3.4.3 Incidental municipal powers. Definition and scope of incidental powers. Section 156(5). Municipalities can exercise powers that are reasonably necessary or incidental to the effective performance of their functions. Incidental powers are powers that fall outside the direct scope of legislative and executive authority of the municipality, are closely connected to performing the municipality's functions effectively, hence are deemed part of the municipality's authority. Purpose. The incidental powers do not create new functional areas but broaden existing powers, allowing municipalities to effectively carry out their functions. Next page. Determining the subject matter of a law. Categories of legislative and executive authority. Municipalities' legislative and executive authority can be divided into three categories. 1. Matters listed in Schedules 4B and 5B of the Constitution. 2. Matters assigned to municipalities by national or provincial governments. 3. Matters that are reasonably necessary or incidental to the effective performance of municipal functions. Case, Lasurin and other v. eThekwini Municipality and others. Facts. In 2010, eThekwini Municipality adopted a resolution amending its town planning scheme to introduce the Durban Metropolitan Open Space System, DMOS, which aimed to protect areas of high biodiversity in Durban. DMOS requires land in designated areas to obtain environmental authorization before development and imposes strict ecological controls. Challenge. The applicant argued that the subject matter of the resolution was the environment, a matter listed in Schedule 4A, which falls under national and provincial competence, and thus outside the municipality's legislative authority. Court's decision. The High Court rejected the challenge. It noted that municipal planning, listed in Schedule 4B, should be interpreted in light of Section 24 of the Constitution, which guarantees the right to an environment not harmful to health. Section 152(1)(d) of the Constitution, which mandates municipalities to promote a safe and healthy environment, supports the idea that municipalities have authority over environmental matters as part of their planning functions. The court also cited Section 23(1)(c) of the Municipal Systems Act, recognizing municipalities' responsibility for integrated development planning, including environmental matters. Conclusion. The court accepted that environmental matters could be classified as incidental to the municipality's planning function. Municipalities have historically regulated environmental matters at the local level, and the Constitution did not exclude them from such regulation. 8.3.5 Conflicting national, provincial, and municipal laws. Conflict resolution. Section 156(3) of the Constitution. Conflicts between laws. Conflicts may arise between national, provincial, and municipal laws, particularly concerning matters in Schedules 4B and 5B. Section 156(3) resolves these conflicts. Municipal bylaws that conflict with national or provincial legislation are invalid. A municipality must exercise its authority within the limits set by national or provincial law. Exception: if no national or provincial law regulates a local government matter, the municipality is free to determine its own legislative and executive decisions without external constraints. Next page. 8.3.6 Supervision of local government. While local government holds legislative and executive powers, the Constitution recognizes its relative weakness and lack of capacity. Thus, national and provincial governments have supervisory powers over local government, which are divided into 4 categories. 1. Power to monitor local government. Section 155(6). Provincial governments must monitor and support local government, ensuring municipalities can perform their functions and manage their own affairs. The Constitutional Court in the first certification judgment held that monitoring does not involve control, but rather observation or review of municipal management. It is the least intrusive power. 2. Power to support local government. Section 154(1). National and provincial governments must support municipalities by strengthening their capacity to manage their affairs, exercise powers, and perform functions. The first certification judgment explained that this power helps prevent decline in municipal structures and functions, making it more intrusive than monitoring but less so than regulation or intervention. 3. Power to regulate local government. Section 155(7). National and provincial governments can regulate the exercise of municipal powers to ensure effective performance of municipal functions in relation to matters in Schedules 4 and 5. The Constitutional Court in the first certification judgment stated that this power allows control over the manner in which municipalities manage their affairs, but does not authorize national or provincial governments to perform municipal functions. 4. Power to intervene in local government. Section 139(1). If a municipality fails to fulfill its constitutional or legal obligations, the provincial executive can intervene by taking appropriate steps, including issuing directives, assuming responsibility, or dissolving the municipal council. This power is considered hands-on and is the most intrusive of the supervisory powers. Safeguards for intervention. Intervention must be limited to the specific obligation the municipality is failing to fulfill. It must be necessary to maintain essential national standards or meet minimum service standards. It must be necessary to prevent actions prejudicial to other municipalities or the province. Intervention must maintain economic unity. Prior written notice is required, fostering friendly relations between the municipality and provincial government. Dissolution of the municipal council can only occur as a last resort under exceptional circumstances. 5. Budgetary interventions. Section 139(4). If a municipality fails to approve a budget or revenue-raising measures, the national or provincial executive must intervene to ensure approval. Constitutional Court in Fetcher confirmed that the approval of the budget is a legislative act, and the provincial executive may intervene where the municipality fails to meet this obligation. Guidelines from Premier, Western Cape v. Overberg Municipality, SCA. The provincial executive must intervene if a municipality fails to approve the budget or revenue-raising measures. Less drastic measures should be considered before dissolving the council. The steps taken must ensure budget approval. Dissolution can only be a last resort. 6. Financial crises interventions, Section 139(5). In cases of financial crises, where a municipality is in material breach of obligations or unable to meet financial commitments, the national or provincial executive must implement a recovery plan, dissolve the council, or assume responsibility for the recovery plan. Next. Page 8.4 Financial Affairs. 8.4.1 Introduction. Fiscal Powers Division. Chapter 13 of the Constitution regulates fiscal powers, outlining the distribution of financial powers among the national, provincial, and local governments. Regulatory bodies, establishes the Central Bank and the Fiscal and Financial Commission, FFC. Fiscal federalism, centralized in South Africa, with the national sphere holding significant power over tax collection and distribution. 8.4.2 The division of fiscal powers. Revenue distribution, centralized in the national government, with some limited power given to provinces and municipalities. Challenges. Whether revenue should be distributed or centralized. If centralized, how to allocate funds between spheres of government. Decisions about allocation and the role of third parties in this process. 8.4.3 The collection of revenue. National government's power. The Constitution restricts provincial and local governments' ability to impose taxes, leaving major revenue sources, for example, income tax, VAT, etc., under national control. Provincial government, Section 228, may impose taxes, levies, and duties, excluding key sources like income tax and VAT. Restrictions to prevent prejudicing national policies, economic activities, or mobility. Regulated by the Provincial Tax Regulation Process Act. Municipalities, Section 229, may impose property rates and surcharges, but limited to certain taxes, excluding VAT, income tax, and customs duties. Regulated by national legislation such as the Municipal Property Rates Act and Municipal Fiscal Powers and Functions Act. Determining state property for rates. State property exemption. Section 3 of the Rating of State Property Act exempts state land held in trust from municipal rates. Ingonyama Trust case. The SCA ruled that land owned by the Ingonyama Trust was state property, exempting it from rates. Key factors. Minister-appointed trustees, administration funded by the Department of Land Affairs. Trusts financials audited by the Auditor General and land classified as state land in multiple laws. Next. Page 8.4.4 The distribution of revenue. Section 214(1) of the Constitution mandates an Act of Parliament to equitably divide national revenue among national, provincial, and local governments. Determine each province's share of the provincial portion of national revenue. Define other allocations to provinces, local governments, or municipalities, including conditions. The Division of Revenue Act, DORA, is passed annually to comply with this provision. Section 214(2) requires DORA to be passed after consultations with provincial governments, organized local government, and the Financial and Fiscal Commission, FFC. DORA must consider national interests and obligations, including national debt, the fiscal needs and capacity of provinces and municipalities, the economic disparities between provinces and municipalities, stability and predictability of revenue allocations. The FFC must submit recommendations for equitable revenue distribution to the Minister of Finance, Parliament, and provincial legislatures 10 months before each financial year. The Minister of Finance then consults with the FFC, provinces, and local governments before introducing the Division of Revenue Bill. The formula for dividing national revenue is based on multiple components, with separate allocations for provinces and municipalities. Section 227 of the Constitution emphasizes that provinces must use their equitable share for basic services and allocated functions. 8.4.5 The budgetary process. Section 215(1) requires the national, provincial, and municipal budgets to promote transparency, accountability, and effective financial management. Section 215(2) stipulates that national legislation must define the form of budgets at all levels of government. When budgets must be tabled and the sources of revenue and proposed expenditures, budgets must include revenue and expenditure estimates, capital versus current, proposals for financing deficits and public debt management. Public Finance Management Act, PFMA, ensures public financial management in line with Section 215. Section 27(1) requires the Minister of Finance to table the national budget before the start of the financial year. Section 27(3) outlines the required budget components, including revenue, expenditure estimates, debt servicing, and capital expenditure projections. The PFMA ensures compliance with Section 216 of the Constitution, establishing a national treasury and ensuring transparency and expenditure control across government levels. The National Treasury, headed by the Minister of Finance, is responsible for promoting fiscal policy, coordinating economic policies, and managing budget preparation and implementation, facilitating and monitoring the division of revenue and ensuring transparency in public finance. Section 11 of the PFMA, the National Treasury oversees the National Revenue Fund, NRF, established by Section 213 of the Constitution. The NRF collects all money received by the national government, except as excluded by law, and may only be accessed through an appropriation or direct charge. Each provincial treasury is headed by the MEC for Finance, responsible for preparing and managing the provincial budget, ensuring transparent management of provincial finances and adherence to national economic policies. Section 21 of the PFMA, provincial revenue funds are managed by each provincial treasury, collecting all provincial revenue except as excluded by law. Money can only be withdrawn through provincial acts or direct charges specified in the Constitution. Next. Page 8.4.6 The Central Bank. Section 223 of the Constitution designates the Reserve Bank as the Central Bank of South Africa, regulated by the South African Reserve Bank Act. Section 224(1) defines the primary objective of the Reserve Bank as protecting the currency's value to support balanced and sustainable economic growth. Section 224(2) ensures the independence of the Reserve Bank, mandating that it operates without external influence but requires regular consultation with the Minister of Finance. Key functions of the Reserve Bank: monetary policy, implements measures to influence money supply and interest rates to stabilize prices, promote employment, and foster economic growth. It sets interest rates affecting consumer borrowing costs. Provision of liquidity to banks, provides temporary liquidity support to banks facing cash shortages to prevent bankruptcy and safeguard customer deposits. Issuance of bank notes and coins, holds exclusive authority to issue and destroy currency. Banker of other banks, custodian of required cash reserves that banks must hold. The Reserve Bank's role in economic policy formulation is crucial, with decisions impacting the country's economy and citizens' lives. Its independence allows it to act in the nation's long-term interests, unaffected by political pressures. Absa Bank Limited and others v. Public Protector, the High Court emphasized the Reserve Bank's independence, ruling that it should act as a lender of last resort to prevent banking instability, a function shared globally by central banks. The court recognized the bank's expertise in financial matters and stressed that its discretionary powers should not be interfered with by other state organs, such as the Public Protector. Next. Page 8.4.7 Procurement. 8.4.7.1 Introduction. Section 217 of the Constitution mandates that organs of state at all levels must procure goods and services in a manner that is fair, equitable, transparent, competitive, and cost-effective. However, procurement policies may still provide for preferences to be given to previously disadvantaged groups. National legislation must be enacted to establish a framework for implementing these preferences, namely the Preferential Procurement Policy Framework Act, PFA. Case law. Millennium Waste Management, Proprietary, Limited v. Chairperson of the Tender Board, Limpopo Province and others. The SCA ruled that tenders must be evaluated in line with the constitutional values in Section 217. The appellant had been disqualified for a minor procedural defect, not signing a declaration of interest, despite having a significantly lower bid than the successful tenderer. The SCA found that the decision was administrative action under PAHA and should align with constitutional values. The failure to sign was a minor irregularity, and condonation should have been allowed to promote fairness and competitiveness. The SCA emphasized that tender processes must be judged in terms of fairness, competitiveness, and cost-effectiveness, rather than rigidly adhering to technicalities. The court ruled to set aside the tender award and instructed the tender board to reconsider the bids, focusing on the broader constitutional values. Minister of Social Development and others v. Phoenix Cash and Carry PMBCC. The SCA reiterated that the principles of fairness, transparency, competitiveness, and cost-effectiveness must guide the tender process. Phoenix bid was 40% cheaper than the successful tender, yet it was disqualified for non-compliance with certain prerequisites. The SCA criticized the department's focus on form over substance, ruling that excluding the Phoenix bid due to minor non-compliance was unreasonable. The court emphasized that uncertain criteria and technicalities should not be used to exclude meritorious tenders and that clear formalities should be prescribed in tender processes. Alpay Consolidated Investment Holding, Proprietary, Limited and others v. Chief Executive Officer of the South African Social Security Agency and others. The Constitutional Court held that inconsequential irregularities in procurement cannot automatically be disregarded. Compliance with formalities serves key purposes, ensuring fairness, improving efficiency, and preventing corrupt influences. The court stressed that irregularities must be material to the outcome, and not every flaw justifies invalidating a public contract. PAHA requires a two-step analysis. 1. Determine if an irregularity occurred. 2. Evaluate if the irregularity justifies judicial review under PAHA. Key principles. Fairness. The tender process must be evaluated on substance over form. Cost-effectiveness. Significant price differences should be explained and justified. Condonation. Minor non-compliance can be condoned when it does not conflict with public interest or constitutional values. Judicial review. Irregularities must be material and evaluated within the context of PAHA and constitutional principles. Next page. Dealing with disparities in price. When a tender is awarded to a body that did not submit the lowest bid, it can result in the state paying more for a service or a product. In this scenario, Cleaners Incorporated, a consortium of African female cleaners, bids are 10,000 more per month than Sparkling Clean CC, a national company. The question arises as to whether government procurement policy should aim to address economic disparities or whether the government should focus on obtaining the best value for money, given its limited budget. Factors to consider. 1. Constitutional and legal framework. Section 217 of the Constitution mandates that procurement must be fair, equitable, transparent, competitive, and cost-effective. However, the Constitution also allows for preferential procurement policies to address past inequalities, particularly benefiting groups that were historically disadvantaged. This aligns with the Preferential Procurement Policy Framework Act, PFA, which allows preferences for those previously disadvantaged. 2. Government's role in bridging economic disparities. Government procurement policies can be seen as a tool for economic transformation, where preferential treatment is given to groups that face economic disadvantages. In this case, Cleaners Incorporated, mostly African female workers, many of whom are sole breadwinners, may represent a disadvantaged group, and awarding the contract to them could have broader social and economic benefits by supporting economic empowerment and promoting gender equality. 3. Cost-effectiveness and public interest. However, the government is under pressure to maximize the value for money and ensure that taxpayer funds are spent efficiently. The higher bid by Cleaners Incorporated may put additional strain on a limited budget, especially if Sparkling Clean CC's bid is equally capable of providing the service at a lower cost. Cost-effectiveness is a key constitutional value in procurement, and the government must weigh the economic benefits of promoting equity against the cost of the contract. 4. Balancing both objectives. The question lies in finding a balance between economic transformation and value for money. The government must decide whether the additional cost of awarding the contract to a disadvantaged group is justified by the long-term social benefits, such as promoting employment equity, skills development, and social upliftment. 5. Judicial oversight and tender decisions. In previous cases, such as Millennium Waste Management and Phoenix Cash and Carry, courts have emphasized that the 5 constitutional values, fairness, competitiveness, transparency, cost-effectiveness, and equity, should guide the procurement process. Courts have ruled that when decisions are made, they should not focus only on price but must consider broader constitutional goals, including the promotion of social justice and economic equality. Conclusion. The government should aim to strike a balance between obtaining best value and using procurement as a tool for socio-economic transformation. While price is important, economic empowerment, particularly for historically disadvantaged groups, should also be factored into the decision-making process. Ultimately, government procurement decisions must align with constitutional values, and the public interest could justify paying more for a contract if the broader societal benefits of addressing disparities in economic opportunity are clear. Next Page 8.4.7.2 The Preferential Procurement Policy Framework Act 5 of 2000. The Preferential Procurement Policy Framework Act, PFA, provides a framework for implementing preferential procurement policies, as permitted by Section 217(2) of the Constitution. This allows public bodies to determine and implement procurement policies that prioritize historically disadvantaged groups. Key provisions of the PFA. Section 2 of the PFA distinguishes between contracts above the prescribed amount. A maximum of 10 points can be allocated for specific goals, for example, race, gender, disability. Contracts below the prescribed amount. A maximum of 20 points can be allocated for these goals. Specific goals. The goals in the PFA focus on addressing historical disadvantages, based on race, gender, sex, or disability. Supporting the Reconstruction and Development Program, RDP. Tender process. The process involves inviting tenders for a formal proposal, evaluating tenders based on specific criteria, ranking bids according to evaluation criteria, scoring and tender evaluation. Under the 2011 regulations, the scoring system heavily prioritized price while also considering equity issues. However, the 2017 regulations, which repealed the 2011 regulations, introduced more flexibility in procurement decisions. Notable changes in the 2017 regulations. Objective criteria. Public bodies must specify objective criteria in the tender advertisement, such as local industrial development, socioeconomic transformation, empowerment of small businesses, rural and township enterprises, and cooperatives. Subcontracting. The tender advertisement may require the successful bidder to subcontract at least 30% of the contract value to designated groups. Market-related price. If the highest scoring bid is not market-related, the contracting body may negotiate a market-related price. If negotiations with the highest bidder fail, the body can negotiate with the second or third highest bidder. If no agreement is reached, the tender may be cancelled. Summary. The PFA and its regulations enable flexibility in procurement policies to support economic transformation while still focusing on ensuring fair competition and cost-effectiveness. The 2017 regulations allow public bodies to focus not just on price, but also on local development, small business empowerment, and designated groups, giving public bodies more room for discretion in awarding tenders. Next. Page. Summary. Horizontal division of power. The Constitution establishes a quasi-federal system with power divided horizontally between national, provincial, and local governments. This system follows an integrated model of federalism, where policymaking and lawmaking powers are shared across different levels of government. The principle of cooperative government requires the spheres to work together, regardless of the political party in power. Role of National Council of Provinces, NCOP. The NCOP plays a key role in coordinating the legislative activities of the three spheres of government. Provincial government. The provincial executive is headed by a premier, elected by the provincial legislature, who can also be removed by the legislature. Provinces have executive authority over the functional areas in Schedules 4, concurrent powers, and 5, exclusive powers, of the Constitution. Provincial legislatures operate similarly to the national legislature but with one house. When both national and provincial legislatures pass conflicting legislation on Schedule 4 areas, provincial legislation prevails unless specific conditions in Section 146 apply. National legislation can only pass on Schedule 5 areas in exceptional circumstances as per Section 44(2). The pith and substance test is applied to determine whether a bill falls under Schedule 4 or Schedule 5. Local government. Local government is constitutionally recognized and has original and entrenched powers. Local government duties are outlined in Section 152(1) and defined in Sections 155 and 156. Municipalities are categorized as Category A, metropolitan municipalities with exclusive authority. Category B, local municipalities with shared authority with Category C municipalities. Category C, district municipalities with authority covering multiple local municipalities. Section 156(3) resolves conflicts between municipal bylaws and national/provincial laws, making conflicting bylaws invalid. Municipalities can determine legislative and executive decisions when national or provincial laws are absent. Financial arrangements. The national government has significant power over revenue collection, While provincial and local governments have limited taxation powers, the Constitution provides for an equitable share of nationally collected revenue for provinces and municipalities. Section 215(1) mandates that national, provincial, and municipal budgetary processes promote transparency, accountability, and effective financial management. Section 217 requires that contracting for goods and services by any government sphere be fair, equitable, transparent, competitive, and cost-effective.